Hi guys, it's Kathy. I hope you're doing well. Man, I slept a lot today, but phew, I'm tired. Did you ever do that? Did you ever sleep a lot and then you're still just more tired than you were when you fell asleep? That is me today. I'm trying. We get to the end today. We do. 11 waiting. 11 cents. You don't know. Oh, yes, you do know what that means, Donald. You're the one in here who knows. And Shinny, we are not going, and Jen, we are not going to talk about 11 today. No, absolutely not. Somebody leave. Just kidding. It'll be at 12 in a second. Hi, Jen. 14. Thank you. Now I can move on. Now I don't have to worry about 11 cents for another 2 hours, guys. I know if you don't know what that means, it's OJ. It's all about OJ, and trust me, 11 cents is important. And you guys have all been through the OJ. You lived through it. Anybody remember the 11 cents? Don't answer that, kids who are watching. They sure talk about it in trial a lot, though. Ha! Mike goes here. Kelly, you don't know how good it makes me feel that you just went a day without coughing. Whew. It's okay. It was it was just frustration. It was frustration after frustration. Well, last night or whatever. We're going back to frustration right now, but I forgot to share my screen. And you can't see what I see if I don't share my screen. And someone just sent me a text message. Everybody who knows me has to know I'm working right now, which means... Oh no, it wasn't Fozzie. Fozzie's behaving. It's lovely. It's silent for just a couple seconds. So don't freak out. Where's the sound? There's no sound.
Okay, what happened to Mr. Shannon?
Yeah.
Oh, I didn't see you. Okay.
He was hiding from. I don't want to disappoint you, Your Honor. I'm back. I'm so sorry.
Okay. All right, you're still under oath, Miss Parker. And counsel, let's proceed.
Yes, Your Honor. And, okay. I want to switch topics for a second and then get back to your worksheets. What was that? It was the other day. There was that one that you pulled off to the side and you said, are you admitting this one? It was like 32 maybe. It was just a cover sheet of expenses. 40? You have it? Okay, fine. Ma'am, earlier you submitted, it was a breakdown of what my client had submitted to you for some expenses and things like that, correct?
It was just some that I printed out from Family
From our
Wizard.
Family Wizard, right? Okay, I just
Correct.
wanted to make sure. And so, you took that off our Family Wizard, and your attorney, I think, admitted it, right?
Correct.
Okay, and
It wasn't all of them, though.
I get it. I'm handing you what we'll call, so that would have been 40? The one that I didn't admit, that was 40? Okay, this would replace 40, which was yesterday, which was just a thing that's in expenses. Is this pretty much a similar thing right off our Family Wizard? Do you recognize that? It came off our Family.
I mean, it looks very different. I printed a different format. It just,
But do you disagree that this shows what my client is, when you put it in here, and what shows up to you on?
it looks like, yes, sir.
So, Your Honor, I would like to tender this as 40.
All right, plaintiff's 40. Any objection? Haven't seen objection.
All copy. This was kind of the same thing.
All right, admit it.
Did I give you?
Do we really want to hear him?
Now,
Do we?
I'll ask you another question, just since we're trying to deal with everything today. You've been providing health insurance for the children, correct?
Correct.
Because you work for the city.
County.
The county, okay. And do you have any issue with, since you do have a good health insurance, continuing to cover your children?
Not at all. well, so I've always provided their health insurance.
Okay, I just wanted to make sure that we were covered on that.
And Parker is, if you look on the insurance card, it is one card for each of us. So it's Parker, Cole, and myself.
Okay. Very well. Now, ma'am, we went through the alimony. You'll concede to me that tell me, do you agree with me that it's perhaps possible you made some mistakes at least on the alimony?
So the 2018 is from the temporary order, and then the other
Just
12
frankincense today.
Well, the
cover
other
his alimony.
Thanks, Maria.
13 payments though, of the 2,000, which was one overpayment, correct?
Correct, but 2018 was under the temporary order.
Well, yeah, we actually started from September 2018. So from
Correct.
September 2018 forward, there was 13 payments, meaning one overpayment, and that was it.
Correct.
Okay.
Yes.
So it was incorrect on that chart that it said that he's in arrears $6,000.
Correct.
Okay. So it's possible that there could be some mistakes. Yes?
Correct. I identified from what you gave me yesterday, I identified those
Okay. Now,
on the spreadsheet.
ma'am, I'm also going to ask you, I thought we were done with low country drug screening, but I was wrong.
Okay.
Going back to your chart on low country drug
No
screening.
take backs. No.
And I noticed that you had my client in arrears. I don't know. Okay. You have my client in arrears, and you started his
450.
arrearage for low country drug screening on September 1st, 2018.
Correct. It's prorated.
Well, you prorated it. Again, you gave him some credit here, like you said, for 15.28, or that's what you said you did, for the first 15.28 months, right?
Correct. I took the order, met with Mike, the accountant that does my taxes, and he assisted in putting together the spreadsheet.
So it's not,
So-
this isn't an easy task. You need an
No,
accountant to help
listen.
you
No, absolutely. I mean, I have done all of this for you and your client and all of us together to show my records and then some of the records that I've been provided with. I've put it all together, matched it. I've done a lot of work on all of
So
those.
it's possible, though, that there could be some honest mistakes.
Of course, the ones I identified,
Okay? Well, let me ask you
I'm
this.
fine with that.
The final order came out on September 18th, 2018, correct?
Correct.
And you marked my client already. You started crediting him as of September 1st, 2018, right?
Correct.
Is it possible that my client, since it came out September 18th, 2018, considered the first payment to be October 1st, 2018 for the first obligation?
How he considered it is up to him.
I understand.
I can't speak for him.
Right.
So yes, and like I said, I put this together to help track it. That's why I submitted to you all. That's why I provided my bank records. And so,
So if we are operating under the assumption that since it came out September 18th, 2018, and my client then went 15.28 months out because of the credit of 19,100.
right, because it would be from those days left in September.
All right. This shirt, you're right. It was not 450, Fozzie. You're right. It was 750. But this is what it looked like when I bought it. This shirt. I wish you could see how it does absolutely. Anyway. Doesn't that shirt look pretty? That's what this is supposed to look like. It does not. That looks shiny. Doesn't it look like it's sparkly? The whole thing is sparkly. I thought the whole shirt was sparkly. The camera does weird things, but it doesn't look like, that's not what I'm wearing. Nope. Yeah, it's $7.50. So what are you supposed to do? Complain?
September from the date, I just did it from the date of the order. So there were days left in September. And
Right,
then the
you
full
started-
month of October.
But you prorated September for a low country payment, which was really a payment that you could say didn't really start officially until October, and then would have had 15.28 months of prorating with your 401k, right? He would
So it would not, so even though the order was put in place September 18th, the low country drug screening payment was the exception to that? It wouldn't start till October?
Let's look at the.
I mean, I guess you could, I mean, it's 150,000 regardless minus
Well,
I mean, so you can do it however you want.
It's not 150,000 because one, he's not in the rear 6.
I said minus the,
Plus all the interest, plus.
Okay.
But that's assuming these things are right. We are assuming the alimony isn't over. So I'm going to go back to the order here. In the equitable division, it doesn't say what month to start. It just says he gets 15.28 months.
oh, okay. Well, then he could start it whenever he wants.
Well,
He could start it next year or,
ma'am, Your Honor, I'm going to ask that she be responsible.
This will piss half of you off. I should not have said that. I should not have said that. It was just a cut from when I worked at Millersville University. It's equality, and there is T in here. But after I made my tea, I realized that tea isn't going to cut it today. So I ordered some strong coffee.
Let him, you respond to the question, let him finish. Only one person speak at a time.
15.28 months. If you started in October, right? Because you said you credited until here. Technically, there would be, if you were carrying forward your credit, it would have been till, I don't know, at least January that there would have been a missing payment. Is that possible?
do you have the check?
America. Red, white, and blue, baby. So, what he did last night, this attorney, was he went backwards. Okay, so remember yesterday I said this guy was paying later and later. So, after so long, that equals you're late a full month, okay? Well, what this attorney did is he went backwards and then turned around. So he went to all of her deposits. Okay? So if she deposited his check that he sent November 29th on December 5th, because it took, X amount of days, he mailed, some checks were Venmoed, some money was Venmoed to her. Some checks were written and mailed to her. So he went to when she deposited the check. All right? And if she deposited the check in December, he actually paid twice in December. So don't try to keep up with him. The judge gives up. The other lawyer gives up. I mean, the other lawyer should be objecting every 5 minutes, saying, "Wait, that's not how this works. That's just not how anything works." But he just gave up. He's like, I'll no objection. You'll see, but don't try to keep up because I tried and it's not possible.
To apply? I mean,
You say, do I have a check for it?
well,
What I'm
like you
saying
provided the check image to prove that I was either correct or incorrect. So, but how it's applied, I guess what you're saying is open to interpretation?
Well, on this, it seems like there is a little bit of lack of clarity, so it is possible that this was open to interpret. If it was done September 18th, he thought the first payment would have been in the first month of credit would have been October, which would be 12 days later. You didn't specify that. On child support, you realize that it actually said for child support to prorate the month, right?
Correct.
Okay, it didn't say that for this, right?
Correct.
Okay, very well. So, moving forward, my client can't control. Will you agree with me? My client can't control when you deposit checks.
Correct, but I tried to deposit them in a very timely manner, which I've shown.
Sometimes you actually didn't deposit them timely, and you actually deposited sometimes more than one check at once, right?
Depending on when I received them.
Well, ma'am,
Free shipping.
that's not exactly true, is it? You sometimes actually intentionally did not deposit them.
No, sir.
Is that in front of your children? No?
Where's the evidence of that? No.
Well, I guess we have
Why
to
would
have
I
the
do
children.
that?
I don't know, except to maybe create some issues. But let me ask you this.
So now he just accused her of not depositing checks that supposedly he gave her just to create issues. So his client paid her the money. Yep, paid her the money, but she just didn't deposit it. She didn't take the money because she wanted to cause issues.
If your numbers and your deposits are all
Rocket
correct,
is only it for you, Jen.
look up here, is what you put in here, I think, was what
Triggered.
you received in every month.
I just triggered
Did this on your
myself.
chart.
Correct.
I'm going to go forward. January of 22. You write that he paid $2,500, but you only had one check for that month. Where did the other check come from?
I have to look. December what? Or what was it? January what?
January of 22, you write that he hadn't been in arrears any month over there in that year. I'm looking through and I don't see any missed check, but you have $2,500 payments on your chart. So he obviously made another payment that at some point you haven't reflected where it is, but you have it on your chart as something he paid. So
You
I'm just
said
not sure
January
why you would be
22.
depositing $2,500 if you only paid you $1,250 and if you did pay you.
Your Honor, could you just answer the question instead of Mr. Schachter repeating himself over and
All
over
right,
again?
Mr. Schachter,
All right,
answer the
so-
question.
These are really small. So for January, let's see, what was the exact date? I have a January 24th deposit of $1,500 and a January 24th. Now these are mobile deposits, so
Anybody do that, Donald?
let's see, that will be, so if you have the check,
Low country
Do you have the check
were
image?
checks, right?
Low Country have been checks and I mobily deposited. And so this is very small, but I can't see. So this check image,
I was cleaning my keyboard.
I'm so sorry. It's so small that I can't see the
typing,
date
but I want to clean it first.
on it. I think it says 1/19. And what was the date of deposit?
These are your charts.
Yes, sir. It should say on there. It should list the date.
The date of deposit.
Yes, sir.
Well, you've got one that says January 19th, 2021, and one that says January 24th, 2022.
Yes, sir. So here's the check image that you gave me for January 19th, 2022. And that's the date on there. So what's the question?
Again, here it says that he paid you $2,500 that month.
Okay.
So there's another payment that at some point you must have deposited from some other month.
Well, I wouldn't know that if I don't have the check image.
Well,
No.
you write over here that there was a
Donald!
payment from January 19th, 2021 that you deposited in 22, as well as a January 24th.
Donald, are you okay?
So,
So if he wrote the, whatever he provided, because I'm looking back in
per your records, you deposited one check a year later.
a year later.
Yeah, January 19th, 2021. On January 22, you deposited one check on January
Let me
19th,
see.
2021.
I can't see.
And you
I can't see what
deposited
you're
one on
talking
January 24th for $1,250.
Okay, well,
Those are your dates and your numbers.
correct. So I clearly made the mistake, 1/19/21. I made a mistake of writing 21 instead of 22, but here is the check for that.
It was his check. He has all the records she has, all right? She took 10 years worth of records and put it in a spreadsheet so she can keep track. This spreadsheet is for her. Hi, CJ. And in one spot, instead of writing 2022, she wrote 2021 by accident. And the lawyer does not understand.
And it is the year 2022. So
So you
my
should-
apologies, I
should
wrote the
check.
date wrong.
Do you show two checks there then?
So there's a check, yes, the check is for, we'll have one deposit for $1,250 and one deposit for $1,500. See, well, when he decided, That's what, on 124.22, I have.
On your chart, it says 1,250, so you're short.
No, I have that as well. 124.22 for 1250, and then I have a deposit for 1,500.
Where do I see the 1,500?
I don't know. I need to see
It's
the.
your chart.
Yes, I know. So it's listed here in the bank records.
From what I can see on there, it looks like there's, you giving him credit, you should have given him credit for 2,500 because you had two checks that month, but in reality, you're saying one of them was for 1,500, so it should have been
119.
even another $250. Do you see that?
Yes.
Okay. So we've got another $1,500 of credit, either overpayment or misapplication. I'm gonna ask you, you have, I guess you have a copy of the binder you gave us, right?
Correct.
Okay. So I'm gonna ask you now to move to the child support for a second.
You're all saying
And-
hi because you're so freaking cute. Cute.
You also have, we have part of your book, you've got some things separated as Venmo payments
Correct.
and showing,
We should tie one of his legs to a stake over here with a little rope so he can't go any further. He is outstandingly failing. However, he really believes that he is Perry Masoning this. He thinks he is winning.
I guess, your account and what Bradley provided to you as part of your supplement, right?
Correct.
Okay. Now, I'm going to start with September 2018. Now, the top of your chart for child support 2018, unlike other months, you have, this looks like the only month where you say September part 1, September part 2. You see that?
Same. What's the date?
In 2018.
Okay. I flipped to that one.
He does more nauseating. And we also have one more vest here, guys. One more vest. That would have been easier for me to say, Kelly.
Got it? Whatever you're looking for.
The bank statement from September.
Okay. So let's go back.
Can I ask you, Mr. Shack, what year you're looking at again?
I've had them for a
Right now
long
it's
time, but
2018.
I just
On the
haven't
child
played them in a while.
Correct.
Let's play them all.
Okay.
Let's
Okay.
play them all.
September 2018. Now, if I look through your September 2018, now, when you put in here things like Tiffany, what was the Tiffany
Those were documents that you all submitted.
that we submitted at the hearing when we actually tried this whole issue in front of Judge Bass? We actually covered most of this already, right?
No, we did. I mean, we did some of it. I don't know. I mean, I just took the records, the statements.
There's actually a
And the-
record and a.
Can she finish her
Financial
answer, please?
Let Mr. Schechter let her finish.
I took the financial records provided.
Okay. And so you recall, we actually had already, it was what, 2 or 3 days of the hearing on this issue. And this Tiffany person testified and was shown
depends on how many pictures it has, was from one of my absolute favorite clips that I've ever got. And it's crazy because I can't remember if it was Judge Peel or Judge Oda or Judge Tepe. They're the three Warren County judges that I always get, and nobody else gets. I don't see them get it. They are YouTube judges, but for some reason, no one else gets those. All right, I always get them, and then I played this clip of this guy freaking out. Daryl Brooks, 100%. The guards had to yank him out, three of them. And he was pro se, and it was Daryl Brooks, like part two. And they said, they asked him a question like, if you read that in a book or something, and he said it depends how many pictures the book has. So, but the funny thing is, before I played my clip, because I play at 4:30 in the morning, somebody else played that clip. Somebody else played that hearing. And I remember there was like one or two comments like, we already saw this, blah, blah, blah. Did you get this from blah, blah, blah? And I was like, what? I didn't know. I didn't know anybody else even watched them.
Now, she worked out where the payments were made that you're saying are missing, right?
She said that there were payments missing.
Correct. And that's actually already in a transcript in the record somewhere that was heard by Judge Bass a couple years ago, right?
Correct.
Okay. And it's really part of this continuing issue that we're here right now.
Correct.
Okay, good. Just want to make sure. So there's more evidence out there that's already been detailed. Now, you saw the final order, and the final order said that the child support obligation, make sure I read it correctly, is to be prorated. So it's $4,187 a month. Is that what it is? Let's make sure. I'm say the wrong amount. $4,187 per month, and there's a footnote. Thing in the child support addendum that says to be prorated. Child support addendum 180. Father shall pay child support to the mother in the amount of $41.87 per month, beginning at the entry of this order, prorated for the month of September. Correct?
Correct.
Okay. September 18th.
I'm scared to
would
bump it
be-
up.
There's 12 days left in the month, right?
All right, I can, but
Now, if you take $4,187.57 and you break that down by day, that would be $139.58 per day.
I did a tiny bit.
I get that.
Okay, that's fine.
Okay.
Sure.
And if I were to multiply that by 12 days, the total amount would be $1,675.02 for the month of September. Does that sound plausible?
Sure.
Okay. Now, I want to go back to your statements here for this time period. And it looks like, if I'm looking through your book and reading it correctly, go forward to 2018. Turn to the tab in here that says, I think, Parla's BOA for, and I'm looking at, it starts at the end of August 2018, but it's 9/10/2018. Do you see that? It's your Bank of America statement. It says cash out $2,000.
Good job, Michael.
What was the date?
If you look on September 10th, 2018, it says, and you're paying Venmo cash out $2,000.
Oh, I'm not muted.
That's what Brad is.
I should mute.
Oh, yes.
Okay, so $2,000 payment that he made on September 7th, 2018.
Yes.
Okay. Then you turn the page to Bradley's Venmo that he had supplied at the time. We have access to that. We have a $1,000 payment, it says support on it, $1,000 payment made September 24th, 2018. You see that? It's just on the next page, right there. So here,
September 24th? Oh,
let's, September 24th.
yes, you paid 1,000 and then
$1,000 that it says support there, right? And if you go down, September 7th, 2018, he also paid you $2,000 and it says support, right?
yes.
Okay. So that's so far $3,000. And then if we turn the page,
Wait a minute. So,
Yes, I do.
so my bank statement, it's 2,000 on September 10th, 2018. And then it says you paid Parla Brigman 2,000 and then 1,000. Okay. Yeah. 9, 7, and 8, 6. But that's August 16th.
well, no.
The 1,000 is August 16th.
What do you see August 16th? I'm not looking at August 16th. September 24th, 2018, 1,000 and
Oh, okay.
2,000. So that's
Yep.
3,000. So in reality, he actually paid you, there was another 2,000 that I just said, but that was alimony. So he paid you $3,000 that month, right? 2,000 for alimony, and
And
really,
1,000 for child support.
well, if you look here, again, let's look, 9/7, let's just make sure, 9/7, 2,000,
Okay, so that's alimony.
let's not even classify what it is.
Oh, well, I thought you were. Okay. How would I know? How do I know where it goes?
Man, at the end of the day, if you get all the money, then you got all the money, whether it's semantics. I mean, I'm not gonna tell you how to classify it. It says support, that could be alimony, or it could be spousal support, whatever it is.
Good idea,
Is
Kay.
there a
Bring us out.
I'm hoping to get to it. Mr. Schechter, what's the question?
I'm asking, so $2,000 here for alimony on 9/7/2018.
Wait a minute. I'm sorry, I've got to object. She just said it was alimony. He said, no, we're not going to classify it. If we're
Okay,
classifying it, we're classifying
There's a
it.
payment for $2,000.
Okay.
Payment for $2,000 on 9/7. There's also a payment for $1,000 on 9/24, right?
Yes.
Okay. And then on your bank statement, you have a 9/10 payment for $2,000. So that's actually $5,000 that was paid.
But that's from Venmo.
Yeah. Yeah, that's from Venmo.
So you're saying that even though he only shows 3,000 from Venmo, he actually paid 5,000 from Venmo?
I'm looking at, where does it show that you deposited?
That's what he
Where's-
said.
It was Venmo.
Okay.
Like it was Venmoed, so this is the
Well,
Venmo.
you showed the Venmo payment here.
Ma'am, I understand it was Venmo. You already told me that. Where was it deposited? And if you say it was Venmoed one more time, where was it deposited? It was Venmoed. Yeah, but where was it deposited? Oh, dear Lord.
On this one, so where's the Venmo for the 1,000? You haven't shown that, but it shows that it went there, same place. You put it in your stack. So we're missing $1,000 that he paid you.
Are you asking her a question?
Yeah,
CJ's is bigger.
Where is that payment on your end? Because you show it in the
Okay,
summary.
all right, you've asked her. She gets it.
I don't know.
Okay, so, and if that were the case, then technically, there's another offset here. We have another reconciliation issue.
Okay.
There's actually more to it than that. Let's go for it. With your son. In the final order, the judge, as you stated earlier, said that basically what he did was he added the tuition into child support, correct?
Correct.
But for September, if you keep going, this is part of your exhibit, you see these screenshots you included in here of bank statement payments circled.
I said.
Now,
I don't know, Michael. I told him I lost my virginity that night. Does that count?
there you go.
Okay.
You see there's a payment there for, this is for school tuition of $942.24 and $1,139.89, both in September of 2018. This is before the order came out,
Okay.
right? So if you add up those amounts,
Okay.
the $1,000 that you're not showing, plus the $942.24 and the $1,139.89, which had already been paid. Going forward, you paid the tuition directly, correct?
Yes, I just followed the order.
Well, I understand, but ma'am, what I'm asking is, September, he had already paid the tuition that was part of that amount, right?
I did not determine it between child support and tuition. I just marked it down as child support
That
or not.
month, though, if I add up these two numbers that he had already paid before the order came out for tuition, which each other month, he didn't make those tuition payments, he just gave you the child support, which included it, right?
Correct.
Okay, so then I have, between these two numbers in September, what he already paid by the time the order came out for tuition, and the $1,000 that you're not accounting for, $3,082.13 for September 2018, which means he overpaid you for that month technically by $1,407.11 if he was only supposed to pay $1,675.02 prorated.
Is that a question?
Yeah, I
Okay.
Ask Mr. Schechter.
Is that-
It needs to be clear that
is
you're
that-
asking, Mr.
Yes, sir, I
Schechter.
see it.
You see? Okay.
Yes, sir, I see it.
Mr. Schechter, hold on. I need you to make it clear that you're asking a question.
Sure. I just asked, did she see it? She said she did.
Well, I didn't hear because you were talking while I was talking to you.
I will break it down and go forward.
Okay.
If we have to go through every payment like this, again, I just got this today.
Mr. Schechter, you don't have to tell me again. You just got it today. I got it.
I mean, he's had it since June.
Well, they're
All
actually
right.
not accurate.
All right, your next question, Mr. Schechter.
Okay, so I'll break it down again. If we have $942.24 and $1,139.89, that would equal $2,082.13 that was paid towards tuition by my client in September.
DC,
Yes, sir.
And we
yay!
have the other $1,000 that
Yes, sir.
we just accounted for, so that would be $3,082.13.
Yes, sir.
Okay, and if the calculations that I went through earlier, showing that it was $139.58 that was due for 12 days,
Yes, sir.
equals $1,675.02.
Yes, sir.
Agree with me that that's correct?
Yes, sir.
Okay, then if my client technically paid
Ginny.
$3,082.13 in September,
Yes, sir.
he would have overpaid me by $1,000.
Yes, sir.
Judge, I'm sorry. Mr. Schechter is just, I mean, he is conflating the temporary order and the final order.
Your Honor.
He's saying, he's giving him, can I finish talking, Mr. Schechter? He is giving, he's trying to give him credit for payments he made under the temporary order for payments he made under the final order. I mean, I mean, this is all, I mean.
I'll let you clean it up on redirect.
This is the whole.
Mr. Schechter, I just, go ahead.
Thank you.
Ask your questions.
Okay. So again, you're already starting off with an arrearage when what we're showing is an overpayment. Do you at least see that? I'm not saying you agree with it.
I see what you're saying.
Okay.
I love you, Jen.
But going forward, if what we're saying is correct, that would throw everything off, no?
If what you're saying is correct, then yes, it would throw everything off.
Your Honor,
Yes.
what I think I'm going to do, because I think to go through every single payment like this with her, she's not sure, it's going to be more difficult, is I'm going to recall my client after. the
Okay, that's fine.
To go through and break down all
Are
this.
you done with Ms. Parker?
You know what? I got one more question.
We finished today. Oh no. That means congratulations in Dutch. I thought it meant happy birthday in Dutch, so I put it up for Linus when it was her birthday. But you know what Linus is really good at? Spotting Dutch language mistakes. So it's not. It's not happy birthday. It's congratulations.
Ma'am, earlier you testified you were going through some stuff with your attorney. You were breaking down what happened. And you said that you read that election, and you said, hey, if these things are true, I wouldn't want to live with me either, right? That was what you said.
To myself, I
Okay.
mean, like,
I'm not
I did
saying you
not
agree.
say that out loud, but I'm like, I mean,
You agree with me that in that
Donald,
affidavit,
thank you so much.
you said that he was defensive about it when you confronted him about it, right?
I just asked him. I just said, "Did you write this?"
I
Because
don't
I
mean-
wasn't sure, like, what was happening. I was very caught off guard. I just didn't understand. So I was just asking.
It took you by surprise.
Yes, I just asked if he wrote it, and he said yes. And he was very defensive. He's like, "I don't want to go to public school," and so I'm like, "Okay, I just."
And whether you dispute it or not,
Space.
you did read in there that he, for instance, recounted the example about you calling his dad or comparing him to Alex Murdaugh. You do recall seeing that in there.
I read that.
Okay,
Yes,
very
correct.
well. Now, you testified, so he was at your house at that time when you got the election, right?
Correct. It was his 16th birthday,
And that was September what?
July 21st.
July
And July
21st.
22nd was the Monday that I got the email.
And you said, when your attorney said, and you were responding and explaining, you said that you decided to yourself, it's okay now, and you let him go. That's what you said.
I just wasn't going to fight it anymore.
understand.
It's not my responsibility to make Bradley follow
Well, hold
the
on.
order.
Can she finish her answer, please?
That's not my
Shaq?
question.
She might be a monster. We've never lived with her. We don't know. She might be worse than what he's saying. He's being nice to her. But I can tell you, you cannot make a 16-year-old do anything. You can't make them live somewhere. You can't make them want to do anything. They're going to do what they're going to do, whether it's right or wrong or in the middle. So she's been going through this for 10 years. She's completely given up. She's completely checked out of it all. So, I mean, she might be a monster. Might be. Who knows? We don't know. But I can get there. I can get to what she's saying easily. I cannot get to what he's saying all the time, though.
Okay,
And-
hold on. Let her finish speaking. Go ahead.
Your Honor, I think that's.
Well, I didn't hear what.
The question was not that. I asked him whether you said, and I just decided I'm going to let him go. That's what she said.
Trying-
All right, and that's what she said, and she was explaining it, but just, I've already heard it already, so you can go on. What's your next question?
So you let him go, and you did not, after that point, say, Bradley, bring the child back to me, right? You didn't say that, did you?
No, because he knows what the order is. And the last time, it just created so much conflict and chaos. And I'm like, I can't just keep doing this.
You've seen your child, you've met up with him from time to time, correct?
I don't get to see him very much.
But you see him whenever you want to, or he
No,
wants to, right?
not whenever I want to. I certainly didn't see him for Thanksgiving or Christmas or anything. I mean, it's too complex. There's too much conflict, and I choose not to engage. And so,
Right, but
he's driving, he's 16, and so, yeah, he'll call and say, hey, can you do lunch? I'm like, sure, I'd love to see you for a few minutes, and we do lunch.
the point is, you said you let him go. You pretty much told him that, because you weren't going to argue anymore, right?
She is not the judge. She is the mom. The court papers said she gets custody. But there was this birthday, and now all of a sudden he didn't want to be around her mom at all anymore. The court still says she gets custody. And he was asking her questions, like, I don't know, trying to get her to say, yeah, that's fine, when that's not fine. That's not what the court said. She can't change that. I don't know why they're asking her what her opinion is on him doing this or that, because she doesn't get to have an opinion. The court ruled on what's supposed to happen. The father and the son are not following along, and they're asking the mom, well, would it be okay if I blah, blah, blah? She doesn't get to tell them whether it's okay or not. She's not the judge.
I was not adding to the conflict because
I
many of
understand.
your arguments have been that
It's fruit. It's just grapes and cauliflower, cantaloupe, and pineapple.
Because I say things, it makes it worse. And so when I say that I let him go, it was more of I'm choosing not to call an emergency hearing and contact my attorney. Mr. Brigman knows what his restrictions are, and if he chooses not to follow them, it's his responsibility, hence my response.
You're recounting your narrative and your interpretation of everything, but your messages actually say, I acknowledge he's with you, and you should move him to your car insurance. That's what you wrote, right?
Because legally...
That's not what I asked. I asked if that's what you wrote.
Yes, I read.
Okay.
It was
Right.
very well thought out, and I was very careful because I didn't want to create more conflict. There's no way to resolve it in those messages in any way, shape, or form.
There's also no place in there where it indicates that my client withheld the child from you or that
That point is already, Mr. Schechter, move on. I've already heard this.
Okay.
She's not contending that. You're not. Just,
Well, hold
we're
on.
done.
That was Mr.
Well,
Johnson's argument.
I understood. I saw what she wrote. I read it. I've heard what she's testified, and I'm not hearing anything different.
Okay, I am, as I said, then going to save the rest for Mr. Briggs.
All right. Any redirect, Mr. Johnson?
Brigman, did you follow any of Mr. Schachter's math?
No, sir.
Okay. One of the things.
In case you missed what he asked if you were following along with what the attorney was trying to ask her. No, she did not understand. None of it.
Things that he got all over you about was the deposits in January of 2022. And he's looking at one spreadsheet when there's three different spreadsheets, right?
Correct.
Okay. Now,
I'm going to object to the leading. This has got to be her testimony, Your Honor.
how many spreadsheets are
Okay.
there?
I didn't create.
All right, Mr. Schechter, let me rule. All right, so stay open-ended, please, Mr. Johnson.
You have a spreadsheet for child support. You
Correct.
have a spreadsheet for Low Country Drug.
Correct.
You have a spreadsheet for alimony.
Correct. So that's 3 spreadsheets.
Three
Yes.
spreadsheets. Okay. And you have put the deposits on the different spreadsheets based upon what they're being applied to.
Correct.
All right. So Mr. Schechter spent 20 minutes going through January.
I'm going to object. Is that a question? That's just a statement.
Mr. Schechter, let him get to the question. I've allowed you lots of leeway.
All right.
So,
Cross.
all right. Ask your question, Mr.
I'm
Johnson.
trying, Judge, and I can give you an edgewise. Look at your spreadsheets for January 22, the month that he was saying that you had not accounted for all of the deposits, in particular a $1,500 deposit that he said you didn't give him credit for on the Low Country Drug Screen.
Correct.
Did you give him credit for the $1,500 deposit somewhere else?
Yes, sir.
Okay, and where did you give him credit for that deposit?
Child support, January 22nd.
Okay.
I deposited on January 24th, 2022, $1,500.
Okay. And sitting up here today with Mr. Schechter going through all his numbers and trying to get you to do math on the fly, are you able to follow it all?
Your Honor, I'm going to object to the characterization. I was forced to do math on this.
Okay, Mr. Schechter, overruled.
Thank you. Are you able, sitting up here with, how many pages is that?
No, I'm not.
I mean, what is this, 1,000 pages of bank statements?
Correct. I did this over a period of several weeks to help all of us out.
With the corrections, the 3 corrections you made, and we're talking about the alimony in just a second, with the 3 corrections that you made as to Low Country child support, based upon the checks that were presented to you yesterday, do you stand by your spreadsheets for child support in Low Country?
Yes.
Okay. Now, as to alimony, did I make a mistake on alimony?
Yes.
Okay. Tell me what I did.
I had presented the sheets at 12 months, and Mr. Johnson misunderstood, and they went to the whole time.
Your Honor, I'm going to
They
object.
extended
I
it.
don't think she
I'm not
can
hearing.
testify.
What's your objection, Mr. Schechter?
She's testifying to what Mr. Johnson thought. How could she be testifying to that? And how can he be a witness? This is a little bit of an issue.
Mr. Johnson, if you made a mistake, I'll let you state in your place what the mistake was. Let's
I
just.
was in my place, and I looked at the spreadsheet for alimony, which is before the court, is defendant 17, and it goes through December of 19. I looked at December of 19 at $6,000. She had the spreadsheet going out longer than the alimony was due.
Okay.
She had it zeroed out as of October 19. I looked at December of 19 because I thought that it carried on, and that's my mistake.
Okay.
And for the record, I'm going to state, I'd like to get this in the record, my continuing objection to this exhibit.
That was so
because I'd like
good.
to make this clear on the record.
That objection is already there.
I know,
I get it.
but I want to clarify why. Because we are relying on problematic worksheets and problematic paperwork to prove, assuming that everything she did is wrong and that the three things that she just said were
Well,
incorrect
and
or
you can
incorrect.
argue that, Mr. Schachter.
Your Honor, the whole premise of this is that we now, coming into this 2 seconds ago, had I not unraveled that, my client would have been basically admitting to being in arrears $6,000 because he led her to say that.
Well, he could bring
plus
his
interest.
own, but he could bring his own proof as to what he paid, Mr. Schachter.
Wait, what? Wait, what did the judge just say? He could have figured all this out on his own? He could do that and then, show where she's wrong? Wait, you can't do stuff like that in a hearing, Judge. Judge, now you need to read one of these books.
So, and that's what he's had an opportunity to do that. Your objection is noted for the record.
Thank you.
All right.
Now, and as to the alimony, there's 13 payments. How much was he supposed to pay under the temporary order?
2,000.
And did that continue through September?
Correct.
I'm going to object to questions about the temporary order. We're not talking about the temporary order.
When he went through the temporary order, and this explains why there's 13 payments.
Okay. Overrule.
They all said it again, Kelly. They said it again.
The temporary payment.
Correct.
I need her to speak up, please.
Oh, yes, correct. It is for the temporary order.
And so there's 12 payments of alimony paid after.
Correct.
Okay. All right. Do you stand by your spreadsheets?
Yes.
Nothing further.
All right. Any other questions?
If he's done, I'm going to move to my client.
All right. Thank you. You can step down, ma'am.
Thank you, ma'am.
All right. Any other witnesses?
Do I turn this back in?
Just hand it to the clerk on your way down. On your way down. The
The
clerk.
last melon.
Any other evidence to present, Mr. Johnson?
No, Your Honor.
All right.
Okay, they rested, let's go.
All right, Mr. Schachter.
Okay, well, I need to see it. Here.
All right.
Okay.
Don't worry, guys. Don't worry, guys. Listen. The husband is getting back on the stand, and his lawyer is going to question him again. And then we will finally understand everything, I'm sure. I'm positive we are finally going to get to the bottom of this.
And Mr. Brickman, you're still under oath.
Yes, be careful.
Okay, Mr. Brickman.
Yes.
Going back,
Follow along a second. We might have to.
were there ever times, first of all, before we get into the payments, that you issued checks or sent checks to Parla or money to Parla when it was not cashed right away?
Yes.
And what happened as a result?
Well, we have all the Family Wizard apps. Anytime there was a check that went more than a week, at the most 2, I'd send her a message asking if she received the check or if there was a reason it hasn't been cashed yet.
Okay. And did she tell you?
I mean, like all the rest of the message apps, no, I wouldn't get a reply. Every once in a while, she'd say she didn't have a
Click
check,
here, okay?
so we'd reissue a check.
So some checks had to be reissued.
Lots of checks had to be reissued.
Do you have any idea why that happened or why she wasn't cashing checks right
Mine's
away?
different than yours because it's a channel.
Other than trying,
Calls for speculation, Your Honor.
No, I'm asking if he knows.
I don't know.
Okay.
You don't know?
I can guess, but it's not.
Okay. Did anybody ever see her, to your knowledge, receive checks?
I've had both boys tell me she's ripped check cups before and thrown them in the trash.
Okay.
Yep, 100%. That's what happened, guys. And we were blaming him for not paying. But really what happened was she got the check, She ripped it up and threw it right in the trash can. Right?
And you why?
No idea.
Okay, so let me ask you this. Going back, you've been through the alimony. One, had you already paid all your temporary alimony?
Yes.
Okay, so your contention that you overpaid
Yes.
alimony by 1 month?
Correct.
Okay. Low country drug screening. Mr. John, let me ask you. Did you prepare any of this?
No, sir.
Okay. All of the documents from the bank accounts that were already submitted and the rest of this notebook right here, who put all that together?
Parla, and assuming her accountant is what she said up here.
Okay. Now let me ask you, if it took her with an accountant weeks to go through because of how confusing she says this was, have you been able to compile and reconcile everything in, I don't know, the last couple hours with the updated sheets?
No, we went through this in June of last year. It took 4 of the accounting people from my company, myself, Gene, and Ansley to go through this, and we reconciliated every check, every payment up until that date, and then our court was canceled due to wheelchair.
Okay. Well, going back, has this already been, has any of this been testified to within, technically, I guess it's the contempt case that's already pending, that's now sort of been rolled in as of yesterday into this one? Is there already testimony proving any of these payments for, I don't know, over a course of 3 days and transcripts in front of Judge Bass?
There are 2018 payments in there from the bank statements that we've already testified against and proven.
Your Honor, I'm gonna, if Mr. Schachter has a transcript of this hearing and he would like to present that to the court, I have no objection. But I'm not gonna have, can I finish, please? But I'm not gonna have Mr. Brigman up here testifying to what he remembers that was testified to in a hearing that was never concluded and there was never an order entered.
Do you have a transcript, Mr. Schachter?
There is one, I'm sure, available that we could probably order. It could be ordered if the court needs to review it. There were 3 days.
Judge, have you met this lawyer yet? Have you met him? Have you not known what he's been about? You just asked him if he has evidence? Come on. Do better.
I think it was 3 days.
And there was no order?
Huh?
There was no order?
No, Your Honor, we were supposed to come back for the 4th day, or whatever, and it got postponed, and then COVID happened, and this never ended.
So then there was no ruling, right?
Right, there's still a bunch of evidence, and
Oh, no. I had that pentakill. I don't care if I didn't screenshot it.
witnesses that are no longer available that were available and testified on the record.
Well, you knew this is what we were coming here for, so why would
If you recall yesterday, I told you I was not prepared to handle this.
But if there was no ruling, then why would you think the contempt had
This
been?
is not part of this case. This is part of the KA case. You may recall the beginning of yesterday, and what my motion had been is that he had filed. I'm not saying you can't handle this, and this isn't outstanding. We said yesterday, Mr. Johnson said, well, I guess we can schedule another date and come back here, and Your Honor said, I'd like to get it all done now. So we've now done it, but we're being required to refute all the stuff that I did not know was going to be part of this.
Let me ask you, are you saying there were exhibits that were submitted in that hearing that would go to
Yes.
any payments your client made?
100%.
Any reason you didn't ask for those exhibits yesterday?
Your Honor, yesterday I was here on our modification case that had nothing to do with this contempt. There was no contempt filed in here.
Okay.
That was my point
All right.
yesterday, is that it's unfair to
I'll
make me
deal with it at
argue
the
on
end.
it.
Answer any questions. Overrule. I'll
Very
let him
well.
ask the question.
Thank you. All I'm asking is, was there, and is there already evidence on all this testimony that we've dealt with, not obviously for the last 2 years or 3 years, but up until that point?
Yes, sir.
Okay. It would have involved 2018 and 19 payments.
Yes, sir.
Okay. And there's transcripts. I'm not asking you what's in the transcripts. And there were exhibits, correct?
Yes, sir.
Was there a witness that testified and actually had charts
Yes, sir.
showing payments?
Yes, sir.
Okay. Very well. And that is
Binders? Do they have binders?
that the Tiffany that they refer to in here when they have in the book Tiffany and they've listed numbers?
Yes.
Okay. So that, she accounts for some of that.
Yes.
Okay. Now, I'm going to hand you the rest of the book and the exhibits, which we will now, I assume, need to tender. Tell me from where we need to tender the backup documents of payments having to do. And
from-
tell me what's in there.
We have to tender from September
Yes, he did.
2018
Lawyerly
until
talk.
today, but we don't have today's. We don't have anything past.
What are you contending, as far as this goes, on September 2018? Well, first of all,
We don't have anything past June 20 of 19.
when you saw the order, did you see where it said that you're to prorate September?
Yes, sir.
Okay. And did you then, have you calculated out what that is to be?
Yes, sir.
$139.58?
Yes, sir.
Okay. Did you make the payment that's reflected in those records of $1,000 in addition to the child support?
Like everything else we proved, I make more than money. I make as much payment as possible, mostly more.
I get it. Is the $1,000 there?
Yes, sir.
If you turn the page in that booklet, are there two payments that are for tuition for September?
Yes, sir.
Okay. And because those were paid and were ultimately later, in the future, you did not make those payments for tuition, correct?
Correct.
Okay. But 2082.13 for tuition, you had already paid in September, correct?
Correct. Like when they say that I always pay late, this is on
Are you
September 6th,
sure?
September 4th.
So is it
it's
your
not late.
contention that by making 3,082.13 in payments when you only owed 1,675.02 prorated for that month, that you overpaid $1,407.11?
Yes, sir.
Okay. And carrying forward, does that create other issues in terms of funding?
It creates tens of thousands.
Okay, so I have a cat that I just named Methany. And she is a little pain in the ass. She's just this big and she's a pain in the ass. And I'm an hour into getting this stream. And she jumps right on my laptop. And I had a decision to make. Right at this moment in time, I had a decision to make. Do I start over and start recording? Because it's a 2-hour stream. Do I start over or do I not start over? This is what happened. I chose not to fix it.
Thousands of dollars worth of interest overage.
Well, hold on a second. If you send a check or make a payment, you were allowed to make payments how often for child support?
Twice a month.
Okay. And each time you sent how much?
$2,100.
Okay. So you would send them 2 times each month.
Correct.
Do you have any control over when she deposits them?
Absolutely not.
And if on her charts she's written down the date that it hit her account, or she put it in her account, or deposited it in her account, do you control when that was?
No, sir.
If you sent her a payment in November and she doesn't deposit it until December, does that mean that that's when you made the payment?
No, sir, but I would have checked within the first 2 weeks to make sure she received the check. If not, we'd have reissued a new check.
Well, I understand, but if her chart reflects when she deposited or when she credits that she got it, and that's not when you actually sent it, does that mean you were in arrears for that month?
Yes, sir.
Would that create a discrepancy each month going forward?
Yes, sir. Of thousands of dollars.
Okay. And starting from September, if we have that going on, and every month she's depositing them and crediting them whenever she decides to deposit them or when she says she receives them. Right.
It's complicated because child support, he Venmos. But the payments that he's making her from his company is paper checks that the company writes and sends out. So, and that's how companies work. So there's 3 different types of payments she gets: alimony, child support, and then this company is paying her something. They owe $150,000 to her, and yeah, she couldn't tear up the checks if they did that.
Contention that this is not what they have reflected, that these sheets are not accurate in terms
Not at
of
all.
when you made payments?
Not at all.
Okay. And putting that aside for a second, before we go through more detail, payments and how you show some of these months, let me ask you this. At any time, did you just stop before July or August, sorry, of 2024, did you ever not make any payments towards child support?
Not knowingly, no.
Were you consistently making payments?
Yes, sir.
So were you willfully not making the proper payments?
Absolutely not.
Okay. So, if anything, what would you attribute this to? Confusion, discrepancy, what would it be?
I mean, I think everybody here would understand this is a very confusing situation. I have done my best to keep track of the monthly payments. I've done my best to make sure her alimony was paid. I've done my very best to make sure my...
And then can we please revisit the fact that, what was it, 7 years ago or 8 years ago? I don't remember the exact date. She wanted one check. She wanted one check a month. And they put a motion in and they went back to court. He wanted things separated, that alimony is the first. Child support is split into 2 payments each month. One was supposed to be at the first of the month. The next was supposed to be at the 15th of the month. I honestly, there's been so much, I cannot remember what he made them agree to about the company payment and when that is paid. But he wanted this all split up in this way, and they went to court for it, and he won. They both have accountants, yes.
company has paid her.
Okay. Low country drug screening. You've seen these sheets here, which, if we look at what was actually tendered, it shows you like 57,000. But in reality, I think the last thing she had said was that if we don't credit you for the alimony, according to her, it's like 5,181.67 by her calculations that low country is in the payments, correct? And you're still paying every month. You still have to keep paying, right?
Yes, sir.
Okay. So you're not actually in arrears of going forward months, right?
No, sir.
Can you make a big Fozzie bear from the snow instead of a snowman and then put it in Discord? You can do this. YouTube it. I'm sure there's a how to make a Fozzie. Yeah, I'm going to definitely. How to make a Fozzie. My phone. Anyway, Fozzie bear snowman. Oh, it's just in paper. The internet. Aww. Aww. I didn't even know this was a thing, guys. I'm probably going to get demonetized for this.
Oh, that's gonna be a terrific Christmas tree. Just bring it inside, guys. Thanks.
Yo, Fozzie, I finally made it.
Hey, Ralph, welcome. Are you late?
Yeah, I've been chasing the truck all the way, and boy, am I exhausted.
Oh, I get truck exhaust. That's funny.
Yeah,
That's a
dog
Donald
jokes.
Oh,
joke.
go inside and tell Mom that.
Gotcha.
Yeah, she loves canine humor.
Okay, boys, put it over there in the corner. Doc, let's get this Holly up here.
Oh, Mrs. Bear, I've been chasing the truck, and boy, whoop!
Oh, my. I guess Fozzie didn't tell you about the icy patch.
Yeah, I guess he
Damn it,
didn't.
Fozzie.
Anyhow, my name's Ralph the dog. I come for the holidays.
More people?
I'll go out and see if there's a spare pillow in the kennel.
Woof, woof! Yeah, bark, bark! Oh,
Don't you
yeah.
just hate it when you
Woof,
can't
woof,
speak
woof,
the
woof.
language?
Aha! Just what I was looking for. Look at this little beauty. Whoa! Boy, is this piano out of tune. I love out of tune pianos. Ba-ba-doo-ba-doo-ba-doo-ba-doo.
Just hear those sleigh bells jingling, ring, ting, tingling too. Out here it's lovely weather for a bear and a snowman like you.
Out here the snow is falling and friends are calling. Yoo-hoo!
Ah,
Come on, it's lovely weather for a bear and a snowman like you.
hey, that's pretty good harmony for a snowman.
Actually, I'm a snowman.
What's a snowman?
Nothing's a snowman. What's a snoo with you? There's a Christmas party.
Donald joke.
Fozzie Bear.
It'll be a perfect party with my friends all there.
We'll be singing the songs we love to sing without a single stop. At the fireplace while we watch the chestnuts pop. But seriously,
Hey, Fozzie, what do you think of the weather we're having?
It's so cold.
How cold is it?
It's so cold that when I opened my refrigerator this morning, there was a polar bear inside trying to keep warm.
But it's always cold at Christmas.
Ah, Christmas. Time for Santa Claus and his 8 prancing reindeer.
That's reindeer.
No, that's snow, darling.
Out here the snow is falling, friends are calling you. Come on, it's lovely weather for a Christmas together with you.
This said Fozzie hugs a snowman. I didn't see it happen.
Man, you guys are the funniest comedy teams in the business.
Stay right where you are. Come in. Come in. Come on.
That was awesome. I'm sorry, we're in the middle of a guys, quit distracting me. I just lost 3 subscribers right there.
When did you start making the payments based on your understanding of the final order that said to start paying $12.50 a month, but first credit the $19,100?
I know exactly when it was. It was March of 2020 when we were closed. It was a hard payment to make. The next payment was hard to make, but we started exactly when I thought we were supposed to start, which was we owed for March 1st of 2020.
Okay, so March, how did you get to March of 2020?
We started the first payment in October of 2018.
Well, hold on. That's when you were fine.
We had the intermission, but I am still going to play a very traumatic video that CJ sent me today at the end. Oh man. Oh man. Oh, it's traumatizing.
Correct. And then if we started in October for that, it would be, August, September, October, November, December, January, February, March, April, May, June.
Why did you say August?
I'm sorry, we started what month?
I'm asking.
September?
Did you let, September is when the order came out. When did you start making?
October 1st.
Okay, October 1st is when you started crediting the 15.28 months / 19,100.
Right, so we have November, December, January, February, March, April, May, June, July, August, September, October, November, December, January.
How many months?
That's 15 months.
Okay, so when would the first payment have been due?
But there was point something after that, so we started the first payment.
So 0.28 also, right?
Yeah. So we started. So
At
the whole
9.
month of February there, it was a big mess for us.
Okay.
I started March 1st of 2020. So at worst case, there's about a half of a month, a little more of February.
Let's be clear here. So your understanding was because.
Let's be clear here.
February would have been 0.28 months, right? You just started evenly in March.
Correct. Yeah, there was nothing telling me what exactly I had to start. It just told me when I had to end by.
And you've made all the payments since then, right?
Correct.
Okay. And if you've made all those payments since then, at the end of the day, you still have to make the same number of payments on the Low Country, correct?
The dollar amount, yes.
So regardless of what it is, you have to pay $12.50 a month, and you've been paying $12.50 a month based on your interpretation every month.
And not missed one.
Okay. And so essentially they're arguing about a calculation of when it started. Did you willfully not make a payment in some way that this was interpreted?
No, sir. We made it in the hardest month possible.
And regardless, are you going to make the same number of payments by the end of it, regardless of the money?
Yes, sir.
Regardless of whether it's a month longer than she expected or 2 months longer?
Yes, sir.
Okay. You haven't missed it?
Or earlier.
Very well. Okay. So is it your contention that you are not in willful contempt of anything with Low Country, if at all? If there's even anything missing based on your interpretation?
Yes, sir.
Okay. And alimony we've already taken care of. Are you asking the court to give you $2,000 for an overpayment since you paid in September? You paid 13 months instead of 12?
Yes, sir.
Okay. Very well. Now, they just went through a whole explanation about a temporary order. Was there any contempt filing saying you didn't pay anything under a temporary order at any point?
Yes, sir.
Here, I'm saying right now, here.
Yeah, right now, yes.
Before Mr. Johnson just brought that up, was there any?
No, sir.
Okay. Now, back to the child support. Before I have you walk through, I think the court understood what we were saying, but whatever the court decides, as whether the court goes with Mr. Johnson's interpretation of once you had one child in your custody, even though December, $4,187 is the obligation. Your contention is it should have been whatever it said for one child non-custodial. Is that right? Correct. And you understand that what you paid in the order, did you look and see that it needed to be reduced in half? That it wasn't, that it was 2,800 instead of 2,100, which would have been half?
Yes, sir.
So that was your interpretation. You figured you just divided in half. Is that right?
Oh, yeah.
Okay. So you may be off on the amounts there. Is that right? Yes, sir. But that would only be from December 2022 forward, correct? January, because you paid December of 2020. Correct. So January up until now, it would be whatever the court decides the amount should have been, whether it was 2,800 or 2,100, correct? Correct. Okay. Are you asking the court, though, to again, since the court reserved, and there were multiple delays on child support, are you asking the court to take into account the obligation based on what should have been ruled on with the change of custody?
Clarice, hello, you
based
made
on,
it.
obviously, the law that I pointed out,
Yay.
to what child support should have been for Parker to you. Yes, sir. Okay, what we submitted as 40 or whatever it was, is that evidence that you have been incurring expenses for Parker this entire time? Yes, sir.
I don't think so, Carla. I honestly think that that the mom's spreadsheet may have had a couple typos, but was what was needed. So she had every month until the loan is paid off or whatever is paid off, and then she said if it was paid or wasn't paid. It is mathematics. That's all it is. And an accountant helped her do it. They went through the bank statements and they found every check. They listed it. There's really nothing else that they needed.
I paid for private schools.
Whether you have every single receipt. Right. Did you have to spend anything for Parker to live with you the last 2 years, 2.5 years? While he was in your custody?
Yes, sir.
By the court's order? Yes, sir. Okay. So regardless of what the amount is, you did incur expenses that you believe would justify child support. Yes, sir. Are you specifically, did you come in here asking, did you want child support?
I'm not asking for child support or anything.
But are you asking to at least get credit to offset what they're claiming if there was some mistake due to the fact that you should have been receiving it?
If I was wrong and I should have been paying child support for a child that was at my house, yes, I'm asking for credit.
For credit for what she should have had to pay you to offset that?
Correct.
And what that amount should have been off of?
Yes, sir.
Okay. Now, I want you, because we do want to put this in the record, obviously.
I prefer when they're folded like that behind the back, you know. Take him away, officer. Oh, yeah. Give him my number. He's going to jail. He's so on for me.
Transcripts that are taking place as part of this earlier. But what do we have here? And if you could pull out what we're going to submit to the court in terms of the proofs of payments and maybe walk us through them when it comes to child support. And what you said, this is Parker's sheets.
I also should remind every single person watching right now, this is a contempt hearing. Multiple contempt charges are against this guy right now. Oh, Yul Brenner? Yes. Anyway, contempt hearings can easily result in jail time. So that's a possibility for a contempt hearing.
Do I need to go through every month?
You want to, I think you should break down the payments. All right. They contend that in September, if you look at their charts,
we win.
September 2018, did you notice that on that 1 month they have two separate payments, part 1 and part 2?
Yes, sir.
Did you see that on any other month?
No, sir.
Okay. Now, you've already explained why you believe your 3,008, you were 1,400 and change, or 1,407.11 over for September. go forward and
What
actually
did he just say?
point out each of those payments, where they are, when they are, and why you believe you are current.
Can I have a chart?
Sure.
Can you have a whiteboard too and a binder?
My only comments.
Oh my God, I know what he needs. I know what these two right here need right now. A calculator. Could someone give him a calculator, please?
Is it okay if I stand up here?
Fine.
Thank you.
In December.
And look, I want to correct.
I mean in October.
Step back one.
That was September that we've already
Go back to
paid.
September, but that was with Mrs. Parker. So just, I want you to clarify and explain what your understanding and why you got what.
In September there was,
I just had to agree with you. I want you to explain what it was.
in September I paid the 942.24 and the 1,139.89 for tuition.
Okay, now, eventually, per the order, 18 days later, it was actually rolled into child support.
Correct.
And you had already paid it.
Correct.
Right? Okay, so did you count that as part of the child support?
It was at the time, yes.
Okay?
For per my Venmo that they have all the accounts of up until the time it was closed.
Let's be clear. They have a copy Mrs. Brigham put together in here that included documents you submitted to her from Venmo.
Yes, from our
Do you have
2019
access to
case.
this Venmo account anymore?
I transferred so much money to her, they closed my account.
Do you have access to these records which we previously furnished that she has tendered in here? Can you even open those?
No, they closed the account.
But we have them because she's put them in here.
Yes, sir.
Okay, so keep going.
There's a payment of 1,000 to Parla on the 24th. There's a
Of what
payment
month? Be very clear, month and year.
9/24/18.
Yep.
There's another payment at 9/7/18 for 2,000.
What would the 2,000 be?
I don't know what she accounts it for. I have a dollar amount I have to meet every month. That's what I do.
Okay. Meaning, you don't know whether she attributes it to child support or.
There's no way I can tell what she does with the money. I send the dollar amount that was required every month. The next payment is on to 10/1, but it's 300. At the bottom, it shows South State Bank check for 2,000. It shows a Heritage check for 9/42/24. Another Heritage check, 1,139. That's tuition for both boys. And then payments for September equals $7,380.13. What we don't see in her records on her bank accounts is a $2,000 check from South State and the difference in the Venmo accounts.
When you say you don't see 2,000, what are you referring to?
There's a South State bank check here for $2,000. I don't know where it went. That's what I paid that month. It's in my bank account.
Okay, very well.
Then you go back to her Venmo, where she shows a deposit in her account. She shows 2,000 and there's 1,000 missing. There's only a $2,000 Venmo payment on 9/10. That $2,000, I assume that would be for alimony.
Okay.
I don't know. And that's all of
Okay.
September.
Okay. Keep going.
Moving to October. There's Venmo for 1,000, Venmo for 300, Venmo for 2,000.
I missed a good part, and you guys didn't catch it, just so you know. He just testified that they closed his Venmo accounts because he sent his wife too much money.
1,000, Venmo for 1,000.
What month?
This is 10/2/18,
So October 2018.
10/15/18.
Jen, that was me telling you what we both missed when we stepped away. Your imaginary husband. Me and you both stepped away at the exact same time, and you still think you have a husband? It was me.
When you change the page to her Venmo of my Venmo account,
Well, hold on a second. Can you see up here? I mean, these are the documents that were supplied. And I'm going to ask you right here, because we are. Take a a look on child support 2018. Do you see anything confusing there?
Things are confusing.
Well,
We both had to have accountants for a reason.
That she lists and the due date that she lists.
The due date for the child support was,
Go on to October 2018 specifically. What, it says October 2018 at the top, correct?
correct,
What date does it say right
No,
over there?
it's not a thing.
11/118.
Is that October or November?
That's November, but it's under October.
It's under October and it says November.
All the dates are messed up on all our charts.
Okay, so do you have any idea whether that's the date she says she received it, the date you sent it, what?
I don't know.
Okay. But
It says the due date, but the due dates are all wrong throughout the whole chart. They're wrong throughout.
So according to her, there's no due date for October at all. November's due date is in October.
Correct.
Is that what that says to you at the top, on the first sheet?
And then November's due in December.
December's due in November.
Correct.
That's not what he said. Let's revisit what he just said.
November's due date is in October.
Correct.
Is that what that says to you at the top, on the first sheet?
And then November's due in December.
December's due in November.
November's due in December. Oh, so December's due in November. Is that what that says?
Correct.
Correct.
Does that make any sense to you?
No, sir.
Okay, well, keep going.
You go into,
Does the court have this sheet in front of it?
Hey,
Does Your Honor have this?
I don't know which one that one is.
This is their chart at the top.
There are multiple charts that I have.
Well, I'm sorry,
Oh, if only there was a way for attorneys to point out documents when there's a lot of documents easily. So, like, they could easily say, Judge, do you know what this one is? If there was only a system that we had in place so that, the lawyer could just point to a document and say, this is, sort of like a number or an exhibit number, maybe.
the child support one for 2018. I just want to make sure that everyone's following along with the fact that even the dates here are not correct.
I don't know. If I have it, it would have been marked as an exhibit.
It's defendant 17, Your Honor.
17.
Do you have 17, Madam Clerk?
No, that won't work.
Pardon?
It's the long.
I don't know. I don't think so.
I have it. So what are you asking?
So I just want to let's clarify for a second. Do you understand what's going on here when she writes that for October 18, the due date was November 1st, 2018, and November 2018, the due date was 12/1/2018?
I don't know why.
Damn, Miguel, that's a great question. I think we have a lot of evidence that he didn't, but do we have any evidence that he did?
Okay, but we're relying on these numbers, or at least everyone's been relying on these.
I'm not relying on them, no.
Okay, so you're contending these charts are not even accurate.
No, unfortunately, there are mistakes in all the way across the board here.
Okay.
My side, her side, and these charts are confusing, but it takes accountants to set this up. Parla didn't do this by herself. I didn't do this by myself. It takes accountants to try to make this work. And there's no way for us to figure out where every payment went. All I was able to do was prove that I sent every check. That was my job.
Well, with no checks, I'm going to transfer.
The transfers, checks.
Keep going. We'll walk through all of these. I'd like you to testify to all the payments that you show.
October 18, 300.
What is he referring to?
This
So
book.
there's the booklet that they supplied, which show Venmo payments too, that are not just the checks. So there's more payments, and that's where we have the discrepancy that we went through.
Okay.
Okay, so there's more here. Keep going.
Venmo 2000, 10/3/18. Venmo payment 1000, 10/15/18. You switch the page to my Venmo account, it shows different amounts. It says a $2,000 and 10/2/18 and a 10/1/18 of $300. The dates are different.
Different meaning in terms of what she's showing on her side and what you're showing on yours?
The difference between when I paid them and when they're in her account. Maybe there's a difference in the days of how long it takes to transfer. It's my experience of Venmo, it's instant. She just testified a second ago that she stuck it in there, so I don't know what days it went into what.
Okay.
Turn the page to her. Let's see, this is her Venmo account. It shows a deposit in there of $924.18. That was the previous month. But 10/1, there's a $300 payment. 10-2, there's a $2,000 payment. 10-10, there's a $1,000 payment.
8,000?
No, 1,000.
1,000.
Oh, you just got your little lawyer so freaking excited there. He thought you said 8,000.
We go into September, October. That's the same thing. It's 18. This is going into our bank account. It's all repetitive information. It's just going through it. Each item, how it's listed in this book.
Okay.
In this book, it shows where I paid the boys' expenses for gaming stuff. It shows expenses for life insurance. These are my bank statements.
Just so we all know, Kelly's the only one that's allowed to try to keep up because none of us can. Just let Kelly do it. She got it.
Very well.
There's the Habersham check of $350 for Parker's fundraiser shown in here.
What's the Habersham check? What do you mean?
She put him in Habersham School after she pulled him out of Calvary.
Okay. Very well.
In October, November. There's Venmo payments of $2,000 on 10/24/18. 11/1/18. There's 1,086 in Venmo cash out. There's Venmo of $2,000 to Parla on 11/9/18. On 11/6/18, there's 1,000.
I'm not really sure what this testimony is, going through saying that there's a bunch of Venmo payments. If there is a specific thing that he thinks is missing, point it out. But just kind of going through and listing a bunch of payments is not helpful to anybody. We're going to be sitting here all day while he goes through and says, there's this, there's that. There's a real simple way for Mr. Brigman to figure this out. If he wants to show us that he's paid everything, he can go and he can add up what he owed. And
Canada! Yes!
I'll be honest, the court is more confused than I've been at the start of this hearing.
Judge, you don't need to be confused. Listen closely. To be clear, no matter what is owed, he definitely paid more than what is owed every month in advanced years, but reverse and never on Saturdays. That's it. You want me to write that down for you?
I don't know what's been paid. I guess you all can give me the evidence and I can try to add it up myself.
And that's the problem.
Okay.
Their sheets were incorrect. They have...
Mr. Schachter, just have your client give me the evidence of what he can prove he paid. If it's on a document, show it to Mr.
They have this. They gave us this.
Okay. Do you object to me looking at that?
No, take the whole thing.
Okay, then just give it to me. I don't need him to go through unless it's not clear that that it was a transfer to her. So these are Zelle or Venmo payments?
These are that we get to the Bank of America earlier.
Okay, I got Bank of America. If those are Venmo payments, just give them to me.
Very well. Venmo and...
however it paid, as long as I can
there's
see.
also some on...
I can't say how, but Canada is about to save my ass. I bought something. It's going to be shipped. And then my eyes won't hurt anymore. Thank you, Canada. Thank you, thank you. Thank you, thank you, thank you, thank you, thank you, Canada. I wish there was a way I could thank Canada.
As long as I can, don't give me that whole book. Pull out the payments.
Oh, it's literally, I think everything is done.
Yeah, that's the rest.
Yep. Here, take it out.
Don't give me that whole book. Pull out the payments.
Include the Heritage Bank payments that were educational.
There is evidence he went to school, though, because it was a group project on getting these numbers together, and he's just relying on her work.
Starts right here.
Okay. Pull it on. Let's go back to 2017. Go forward. Start us in September 2018.
Okay, got it. September.
Maybe you go a month earlier.
I got September, no, I got the month before.
Yeah, just leave it.
August of 2018.
Perfect. Very well. Okay. Good. 43. Okay.
She has a running total.
Which exhibit is that?
And the way spreadsheets work is it just does all the math for you. He paid this amount of money, and then magically the number changes to what it should be.
43.
Any objection to exhibit 43?
No.
A big clip? Yeah. Oh, yeah.
Oh, you need like a binder clip?
Is that big enough? You said no objection?
Look,
No objection.
All right, 40.
Look, Chinny's right. Look how empty the binder is. She ain't going through all that. She's not.
43 is admitted.
Was there anything that you believe is missing within what Ms. Brigman supplied that you gave that we just entered?
Yes, there were checks that weren't deposited in that bank account that they provided for us, so we don't know where they were deposited.
Okay, but are those checks reflected in the exhibits that we tendered yesterday? Are there some checks in there that we given that clearly she signed off on and cashed that are not showing in those bank accounts?
Yes, sir, there are checks
That's what you're saying. Okay.
that are deposited with her signature on the back that were not into that account.
Okay, so there's some kind of reconciliation issue with all that.
Correct.
Okay. And if the court were to find that you are somehow behind or in arrears, some place here, was that an intentional thing?
No, sir, but if it finds me in the rears, I'll definitely pay it.
Okay. Very well. I think the court said you didn't want to hear anything else about the children, correct?
Not that I don't care, but
I understand.
custody's not disputed, so I'm not.
Okay.
Thank you. All right. Any other questions, Ms.?
They're all there.
I handed in earlier.
All the bank statements.
To Mrs. Parker at the beginning, where she was saying that you asked about things on Our Family Wizard that are issues. Why did you ask her about the taxes? Please explain.
Because I still don't know what to do with my taxes. I don't want her or myself to be audited, so I would just like an answer on what I'm supposed to do.
Okay, so when you wrote over 2024, 2025 taxes, why are you confused?
Because my accountant's telling me that Parker lives in my house, and if he hasn't stayed in his mother's house in a certain amount of time, she can't count on her taxes. And before I did that, I wanted to make sure she hadn't done it, because I can wait or not do it at all. But Parker and Cole both make money, and they need to file taxes, and I need to file taxes, and I just don't have an answer.
Okay, so your children work also, and they earn, and they've got to report to you.
They do.
And you either have to claim them as dependents or not, right? And then pay taxes on them.
Correct.
Is that correct? Okay. And so when you asked that, according to the decree, what was your understanding? Who do you get to claim no matter what?
Cole.
Okay. And there has been a change of custody, at least before today, on Parker, correct?
Correct.
So as far as 2024 goes, he's been living with you since at least the end of 2022, correct?
Correct.
Okay. So is that why you were asking that question?
Yes, sir.
Was it to fight about or argue about anything in that decree?
Absolutely not. I just want to know her thoughts. If she claimed him for all of 23, great. If she claims him for 24, great. I just wanted an answer.
Okay. Mr. Brigman, have you at times, whether out of frustration or otherwise, have you ever replied or said anything incorrectly that you shouldn't have said, or that you wish you'd handled differently?
I wish I'd have handled this whole divorce differently.
Okay. Is there a way for you to figure things out and react or work with Mrs. Parker?
Yeah, there is. Read the orders. Follow the orders.
No, sir.
Why do you keep sending her, even though she hadn't talked to Parker in years, why do you keep sending her Parker's grades?
Because she's their mother. I tell her everything about Parker. I told her the day he got his license. I sent her pictures from the DMV. I asked her to come to us. I sent her pictures the first day he drove to school. I asked her to be there. I've sent her pictures of him, his accreditations that he got for his job.
Okay.
I've asked her if she wanted to help with bios of stuff for him. She's his mother. She deserves to know everything possible about him since they don't have a relationship right now.
Okay. And you heard her testimony that she loves him, but whatever happened, happened. Do you believe, or was it your understanding that by you sending updates of Parker, that's just you harassing?
Not at all.
And trying to create problems.
If I thought it was harassing, if she told me it was harassing, I would never send them again. If she doesn't want to know, I understand.
When did she say it was harassment? That he types in My Family Wizard. I know she said she's over it. She doesn't need to read it. But she sees the text when it comes in. But when did she say that he's harassing her by doing that?
On Our Family Wizard, by keeping her updated, are you giving her the kind of information you thought she was supposed to be providing back home when she had told?
It's what I would like, but if she chooses not to do it, I understand.
Okay. Very well. We dealt with all the arrearages. Let me ask you this. There was one other issue. We already established that you're waiting for and they're going to distribute money on Bojangles whenever that happens, but you haven't received it yet.
Yes, sir.
Okay. When it comes to attorney's fees, though, there's an attorney's fees arrearage that you acknowledge exists. Is that correct?
Yes, sir.
And when it comes to the attorney's fees arrearage, you said you tried to take out a loan and you couldn't because of the lien that's against the house.
Right.
Okay. Would you try, are you willing to try to do something to make the payments or work out some kind of payment plan if there's some ability to do that?
Every penny that I get from Bojangles sale, that is my portion.
Your portion.
My portion. I have your payments, and I have a payment to Paul I need to make. I will make everything. Every penny I make will go to you too. And just like everything else, we've spent so much money with
You're
you
going to
two.
pay Parla her portion.
I said my portion only. Just my portion.
Okay, that's what I'm
Not Parla's,
Now,
not
let me ask you
anyone
this.
else's.
Has there been any money that's already been taken out of bank accounts for those liens on FIFA?
Yes, my account, my joint account I have with Ansley, my wife, my joint account I have with my son Parker were all wiped out by garnishment and even shut me in the hole about $3,000.
Okay, do you know how much money they've already collected on it like that?
I don't know.
Okay.
I can tell you. Okay, I know you're hearing that he has to pay $1,000 a month for this, $2,000 a month for that. His company is paying this. The last judge that they had, since he didn't give a good accounting of his income, believe it or not, he just didn't. What's the word? When the judge assumes what your income is instead of you providing it, it's usually minimum wage in cases where dads don't have a job but they should. They say, we're going to assess your income, but that's not the word. It's something assess or assess something. The last judge assessed his income at $12,000 a month. So when you're talking about attorney's fees at $50,000, it's not a lot. It's not.
So whenever they've collected, though, that would already be part of it.
Hi, Amy.
It did not show on anything that we've been sent, and it sure doesn't show on the lien they put on my house for $170,000.
So they still have an outstanding loan plus interest that's making it about $130 or $140, whatever it is, $1,000 against your house, increasing by the day, right?
It's doubled the value of what I owe onto my house.
Okay, but you know that they've already received some money on those 5 days.
Yes,
Okay, and that has not been offset at all.
not at all. Not that I can see.
Do you know how much money that was that they received, or you don't know?
I don't know how much money they got from all 3 of our accounts.
When you say 3 accounts, which accounts? Whose accounts did they come from?
It was my main account at Bank of America that I pay all my bills through, I deposit all my checks at the time through.
Guys, whisper now. Amy has a migraine. Be nice. Amy, turn the volume down. Should I turn the lights off? Is that better, Amy? Yes, that's better.
My joint account, I have Nancy that we pay our bills with, and my custodial account, I have with Parker at the time that he put his money into.
Do you have any idea of the amount that's been taken out, or even a ballpark figure?
I honestly don't know. If I had to guess, I don't know, anywhere between $5,000 and $6,000, $3,000. I don't know, 3 to 5, 6.
There's been a couple $1,000 that have already gone against the FICA. Is that correct?
Right.
Okay. And you'd ask that that be subtracted and credited, is that right?
If anybody can tell me the amount, yes, I would love it accredited to the lien against my house.
Okay. And are you asking that, one, any contempt that the court finds, because it's not willful, one, that there not be any interest added to any of these?
I'm asking yes, and if they would remove the lien, I'll refinance my house and pay them.
Okay. And considering the fact that even the numbers are unreliable, and when payments were made, them counting things as late on a date that they've reflected they deposited, are you contending that there should be no interest?
Correct.
Okay. No further questions at this time.
Any questions, Mr. Johnson? No.
Oh, no.
All right, thank you, sir. You may step down.
Oh, that's right. He gave up.
Anything else, Counselor?
He gave up. He gave up. The other attorney is like, look, no one can cross that because it's just all just confusion. So he's like, I'm not going to question him to try to figure it out. Oh, but he is going to argue. Do not worry.
Nothing from the defendant, Your Honor.
Nothing at this time, Your Honor.
All right, I don't hear any argument.
I will waive and close.
Mr. Johnson.
Your Honor, I sense that the court is frustrated with this case the last couple of days. And I can't imagine why. This is exactly what my client has been dealing with for the last 10 years. Absolute chaos. And that's what I said it was going to be when we got here. And that's exactly what it's been. Absolute chaos. This is not hard. It is real simple to figure this stuff out. How much did you owe? How much did you pay? If he thinks that our spreadsheets are wrong, make an accounting. He's had these since June. All he had to do was take the number of payments that were owed, put them on a sheet of paper, get the checks where he paid it or the Venmo that he paid it, and put them on a sheet of paper. When Ms. Parker testifies to the arrearage, the burden shifts to him to prove that he's paid it. And he has not met that burden. My client acknowledged 3 mistakes that she made and gave him credit for that. I acknowledged the mistake that I made and gave him credit for that. But beyond that, there has been no evidence that her spreadsheets are incorrect. Oh, she wrote 22 instead of 21 on a date. It's pretty obvious that's what happened, that it was a typo. But somehow that undermines the entire spreadsheet. This isn't that difficult. None of this has to be that difficult. But Mr. Brigman will not follow an order. Mr. Brigman does whatever the hell he wants, whenever he wants to do it. And that's been the case since day one. That's why we have been litigating for a decade. We've been litigating with Mr. Brigman for a decade. These folks have probably spent at least $500,000 litigating this stuff. And if you go back and you look at all the orders, every single order says it's caused by Mr. Brigman. Every single psychological exam that's done, caused by Mr. Brigman. Every guardian ad litem report, caused by Mr. Brigman. Everyone knows who's causing this. The chaos is because of this man. Over and over and over again. We've been here for 2 days on something that should have been 2 hours. But instead, we're going through this, whatever this is, this stack of papers that is meant to confuse the court, it does not in any way move the ball forward. Does not in any way undermine my client's testimony. Because they go and they pick out a payment here or a payment there, and they say, well, this wasn't shown or this was shown, and we just picked out one where Mr. Schachter is trying to allege that she didn't account for a payment, and it was right there. He just didn't want to look at the second sheet. So he's looking for ways to try to confuse the court and to try to confuse my client. The fact of the matter is his client is in contempt on a number of issues. And let's start with the attorney's fees. Those attorney's fees have been outstanding for almost 7 years. $86,000 in attorney's fees. That should tell the court what Judge Karp thought of Mr. Brinkman. $86,000, and he has not paid a penny toward that. He says, oh, well, if I ever get my Bojangles money, oh, I can't do it because there's a lien on my house. Not a penny, because he doesn't want to. And Mr. Brinkman only does the things that he wants to do. And if for nothing else than what he's done, that should merit incarceration if he doesn't pay it in the time period that I've set out, 15 days, with interest. With interest, because it is a judgment. It accrues interest as a judgment. It is not a discretionary thing. He owes the money plus interest, period. And he has no excuse, zero excuse for not paying it other than he doesn't want to. And his claim is, oh, I can't afford it. And Mr. Brinkman is going on cruise after cruise, going gambling in Vegas. He's got an answer for everything. He's got an excuse for everything. Oh, I have to borrow from my mom. I have to borrow from my company. I have to do this. Mr. Brinkman goes where he wants to go, cruises when he wants to cruise, gambles when he wants to gamble, buys whatever he wants, and ignores things that he doesn't want to deal with. And then he just creates chaos to cover it up. And that's exactly what's been happening for a decade. And that's what order after order says. So, number one, he is in willful contempt on the attorney's fees, and that alone should merit incarceration. Secondly,
he wants him in jail. He wants him just to go to jail.
He is in contempt in the amounts that we set out for the low country drug screening and the child support. Again, Mr. Schachter puts all this spin on it that he paid something in September, but he didn't have to pay it in September, but then he gets credit for it in September. Who the heck knows what he's talking about?
I'll marry you.
The money is very clear. Either you paid it or you didn't. Show us the checks. Show us the money. Very simple. He's in contempt on the child support. We acknowledged our mistake on the alimony. He's in contempt on the low country drug screening. Now, when we get to trying to sort all this out, you have Mr. Brinkman's pattern of lying, and it's well documented. And I didn't go through each and every lie that Mr. Brinkman had said in the last 2 days, because we'd be here for 5 days. But just to point out a few lies, he comes in and he says she's making $1,000 a month for horseback riding lessons. Zero evidence, no good faith reason for saying that. He comes in and he says she's making all this money on paintings, and here's my proof. Here's pictures of her paintings, except they weren't her paintings. All he had to do was look at the signature. So another lie. He says,
Judge, show the class. We all want to see what that says.
Oh, she texted me, don't touch my fucking truck. Well, I've got the text message. Oh, she must have deleted that. Well, show me your text message. Oh, I can't because she changed her number and I don't have her text messages anymore. He texted her 2 weeks ago on that number. I mean, it's always this lie, over and over and over again.
Yes, sir.
I would love to show you the Venmo receipts, but they closed my Venmo account because I transferred too much money to my ex-wife. I only spent 20 minutes with my son on spring break, except he had him the entire spring break and drove him back to school. Lie after lie after lie after lie. And if you look again back at the orders, for example, there are a number of statements made by different judges. This testimony simply can't be believed talking about him. There is no evidence talking about him. Judge after judge has seen through Mr. Brinkman, and this court saw through Mr. Brinkman in this change of custody case.
Hi, Walter. I don't know why or how he was allowed to say those words, but I didn't know that. And I am so happy that he said those words. Did you guys know that? Judge after judge after judge has called him a liar. And
the orders bear that out. Now, with regard to child support, I don't know what Mr. Brigman's asking for in child support, but the court, I would hope, has some very significant questions about what Mr. Brigman's income actually is. Because what you see is he's getting loans, quote, loans from his business, loans from his mom to pay his expenses, $10,000 here, $20,000 there. And he tried this once before, twice before. At the temporary hearing, he tried this. And he said, Judge Karp said at the temporary hearing, $7,022 shown on father's financial affidavit. The court has imputed to him $12,500 per month, which the court deems as income, notwithstanding this testimony that this is money is borrowed. There is no evidence of any obligation to repay this loan. Final judgment decree of divorce. Defendant's mother, Jean Simmons, testified that he maintained his lifestyle by borrowing and that he incurred interest of $744 per day for 21 days of each month. This would total over $187,000 in interest alone, which vastly exceeds the defendant's ability to pay by any measure of his income. Moreover, there is no evidence of interest payments approaching this amount. The testimony can simply not be believed. And it's almost like a broken record. We come in here every time, he accuses her of everything under the sun, having an affair with Todd Friesman, stealing ammunition from the sheriff's department, bribing people over and over and over again. He makes these ludicrous allegations. And the fact of the matter is he's covering up his bad behavior because he just says these absurd things and hopes that we don't actually look at him. But thankfully, every judge, including Your Honor, has seen through him. Every guardian has seen through him. Every psychologist has seen through him. When he knows that his goose is cooked, for example, on this alarm system thing where he forged my client's name and she got sent to collections, he didn't want to talk about that. He's just I'm going to pay it. Because he doesn't want to have to testify about forging my client's name. So Mr. Brigman causes chaos, and Mr. Schachter candidly enables it. And so this court has all the evidence it needs. Our worksheets show the arrearage, and Mr. Brigman has not met his burden of undermining those worksheets in any meaningful way. And so we're asking the court to adopt our proposed resolution with the exception of the alimony figures. And I still need to argue at some point the motion for attorney's fees that's pending on the underlying custody case. And with regard to that case, my client's throwing her hands up. She can only do what she can do. And, you've got an order that Mr. Brigman ignores from day one. And, it just doesn't have to be this complicated. But everything is complicated with Mr. Brigman. Everything is a game with Mr. Brigman. So, Judge, that's our evidence. I won't belabor the point. I won't beat the dead horse. I think the court gets it. I appreciate the court's time.
All right, thank you.
Breathe, guys. We're about to hear his side. Before we do, because I'm scared it's going to go away before I can ask you at the end, does anybody know where this is? Look at that. Isn't it pretty? Are these all... look, I don't know. Are these all little houses all smushed together? Are they houses? Do you think these are houses? I want to know where that is. In my head, this is Florida and that's Lake Okeechobee. But I feel that Lake Okeechobee is way bigger, so probably not. But that's the only thing that I came up with. But if anybody knows where that is, let me know because I want to go right there. I want to be in there. Okay. Are we good now? Are we relaxed? Are we relaxed and ready for this attorney to get up? Oh, you're right, Donald. Okeechobee is like in the middle. I can't zoom in. It's just my desktop background. Usually they have a thing in the corner. If you like this picture or whatever, I don't see one today. So I don't know where this is. Anyway, it's time to get to the other guys. We breathed for a second. Oh, I lost. Oh no, it's right here. No, it's right here. It's adorable, isn't it? That heart. I know. And then there's another one right below it. I know. I want to go there. I want to be there.
Very nice. But I'm not going to attack Mr. Johnson for doing his job. He does a very good job every single time. But he just went back, referenced things from the divorce. What he fails to mention or recall is when we go back to even income figures at the final hearing, I proved that his client was wrong on her income figures, and they were asking for, 10 years of alimony? She got 1 year of alimony. There were reasons for that. We poked holes in things that she put in sworn affidavits to the court, whether or not he wants to remember that or not. Your Honor, we had a good faith basis for filing this case for modification. Whether everybody liked how it played out, the fact is, one, that my client did prevail on the custody of Parker, and my client has admitted shortcomings, and he is a very flawed person. I think many people are. But one thing that strikes me is that every time we hear from Parla Parker, she's always a victim. She is 100% the victim in everything. She's got no accountability. And yet, the court gave her custody of 2 children, both of who do not want to be with her. They cannot stand being around her. They love her. But that's the reality. Nobody did that but Mrs. Parker. And the fact that they want this court to believe that in all of this, that's just irrelevant, that's not the facts, Mr. Brigman created all this, my client couldn't even talk to or pretty much see the children for a long time, and they were screaming. And at the end of the day, Mr. Johnson made this motion this morning about how he's willfully keeping the child. The law is pretty clear that, one, he definitely wasn't willfully keeping anything. She wasn't even asking. She testified she let the child go. Then she wanted to have it both ways. I wrote to Mr. Johnson multiple times, how do we deal with this? Should we call the court? Can't get a response. There is a response in there where he says, well, obviously your client is not, he is misleading you. But I followed up. He wouldn't even respond, and we never got anything. The child, she read the election. She said, hey, I'm going to let you go. And what's my client supposed to do? He's asking questions, and he's saying in the messages, well, I'm not going to just do this. What can I do? And she won't respond. She didn't come get the child. She doesn't. But Mrs. Parker always needs to be the victim. No accountability. It took 2 to tango. It took 2 to make this horrible mess that unfortunately me and Mr. Johnson have been involved in since these children were much younger. And it's both of their faults. Not just Mr. Brigman. Mrs. Parker bears plenty of blame. We heard testimony at the last hearing. We had to bring in sheriff's deputies or sheriff's officers, someone from Tybee, who admitted that she pretty much used her position to call him on a weekend when nobody else would be able to get it so that my client got incarcerated over something that he should not have been incarcerated over. Your Honor found that he wasn't in contempt after hearing all the evidence. It was a little bit disturbing. And I understand the court already issued an order today on Mrs. Mustin and her attorney's fees. Frankly, she was very hostile. She would not cooperate. She did not. She was not unbiased. Not that that's...
That's the guardian ad litem. Remember at the beginning.
The issue at this point, but the reality...
I've already issued the order.
No, I get that, but the reality is, Your Honor, she didn't speak to Mr. Brigman either.
I've already issued the
order. I get that. That's not... My point is, Mrs. Parker knows how to kick up and scream and manipulate people. She says my client does it. She knows how to do it too, and she's done it for this court. Every single thing is Bradley's always doing the wrong thing. I don't know how it's bad for him to keep her updated on a child that she says she loves, and I'm sure she does, but that she doesn't have any curiosity about. None. And he's trying to keep her updated. But when my client expected to be given information about Cole, and there was joint legal custody that never changed, she felt like she didn't have to do it. And it took us.
And that reminds me of a tiny, quick story. Because I always remember this story. Because, I don't know, anyway. You know, we grew up in the 80s, and as little girls we were taught, you know, how we have, anyway. So, this guy opens this door for this lady. They both live in the same apartment building. And every day he opens this door for one of the other people that live there for 10 years straight. Opens the door for her when she walks out in the morning to go to work. And it was later, one of them was about to move out. And, you know, he says, I open that door for you every single day. Why did you never once say thank you to me? And, you know, because he was upset she never once said thank you for him opening the door for her. And she turned to him and she said, I never asked you to open the door for me. And I love that story because, you know, he feels he deserves a thank you because what he did was nice and kind and everything, but she doesn't owe him a thank you. He feels that he deserves the same thing that he's getting, like he's giving her these updates. He feels he should get the same. Problem is, she doesn't want to talk to him. She does not want to talk to this man at all in any way, shape, or form. So the kids are old enough to talk to him. They don't need mom to pass anything along. She doesn't need to talk to him. And she never asked him for those updates. So him, you know, saying, oh, I'm a saint for giving you these updates, she never asked for them.
Filing a motion a year after Your Honor entered the order, the first order, to get a parenting plan that made that crystal clear that if you look at the dates, that's when she started to even respond, to even give a little bit of information or to acknowledge anything. Up until then, it was on him. He couldn't see the child at school. She, although you heard from Ms. Musson that she approved this Lakeisha person, we never heard anything further. And Mrs. Parker, although she said that she was taking Mrs. Musson's word on it, if you look at the Our Family Wizard messages, she says she did not approve her. She said that she agreed with EPAC and the people that were under the order that everybody knew could not supervise. It was a way of handcuffing my client, not letting him see the child, not having any communication. And you know what? It worked. But what didn't work was Mrs. Parker was herself during that time, and she managed to alienate the child from herself, Cole. Cole grew to detest, unfortunately, he loves her. She said he is mom's.
Why are we arguing this? The child, because he's not in dispute.
Well, hold on. Mr. Johnson just went in and attacked my client's character, his credibility, and everything. And I'm saying we're asking for attorney's fees. That's part of this. We did prevail in part, actually, and should prevail on child support.
Okay, well, I'm not doing attorney's fees right now.
Well, I understand, but it's before the court.
Well,
and so this is all relevant to that. It's relevant.
I'm not hearing attorney's fees right now.
I understand.
Move on to the issues that I am hearing today, which are the concerns.
Well, hold on. So we're skipping the modification of child support, which was one of the reserved issues?
Well, and the child support,
that was important.
But what you're arguing doesn't have anything to do with that.
Well, neither did his, where he sat there going back to the divorce.
Mr. Schachter, he talked about his credibility.
Okay,
so
and I'm saying...
I don't mind you arguing her credibility, but not about...
And I'm very...
Great legal comeback. Well, he's allowed to, so I should be allowed to. But yeah, it was way different.
Well, and I'm saying it's the same credibility. She abused her power to try to make the case what she wanted it to be. She takes very makes calculated decisions to try to give her rendition, just showing the taxes, which was an innocent question that I think everybody can see should be an issue, but she jumped to the conclusion that he's just trying to renegotiate. We know that if a child is with one parent, the attorneys here know that that's usually who gets the claim. If he's asking a question because the child that was with her every year has still been his claim, and now he has the second child, that's a legitimate question. She thinks it's threatening, it's horrible, it's bullying, it's harassing. It's an innocent question that needed to be resolved. But that's a problem for Mrs. Parker. I'll go down my proposed relief, Your Honor, and tie that in. One, obviously, the court it sounds like they have conceded on the custody. Frankly, the child is doing, looks like school-wise is doing well, happy. So that's a good thing. And my client going forward should have Cole Brigman. Now, when it comes to child support, and this does need to be addressed, We filed this case back in 2019, and whatever, there was even testimony, and if the court recalls, there was a period where they were doing 50-50 kind of by agreement throughout the proceedings until Ms. Musson got involved, and suddenly there was supervised and taking away custody. That changed things, but it didn't change the obligations, that's for sure. But if you look at the final decree, I think it's...
That's like me saying to you, Tim Tams are cookies, right? That's what you just did to me, CJ. Just so you know. It was like an uppercut.
They can try to argue the verbiage however they want to, but it does say here that he has to pay child support of $4,187 per month. And that, if you look in the addendum, it says, when there is only one child for whom child support is owed, the non-custodial parent shall pay child support of $2,860 per month beginning on the due date of the next child support payment. Well, he no longer owed for 2 children because custody had changed at that point. And as I pointed out, and I read the Anenema case, and if the court wants the copy of it, if the court can pull it, I have the site, or I can give you a copy of the case if you'd like it.
You can give me a copy.
It's a 2024 case, and it makes very clear that that child support, when a court order in custody had changed, but there had not been an entry of an order, that the court, I'm going to have to find it in here, I do have it.
That's okay.
But it's...
Who thinks this lawyer has gotten paid in the last 10 years? No, he keeps telling the lawyers he's going to pay them from the Bojangles money.
That the court can credit for the support that should have been owed for that child. And in this case, my client had custody of 1 child from December 2022, per your Honor's order, going forward. And so there should have been child support. There then needed to be 2 child support worksheets. One from Parker, for Mrs. Parker, to my client for Parker Brigman, who, although he is 19, he is full-time in high school. He's not yet 20, and he's going to be graduating, and I think it's 2 months under his, in 2 months he'll graduate, but there still is child support. And there has been this...
He's almost 20, which why I said he was an adult, so it doesn't matter anymore. But we just found out he's still in high school. So it does absolutely matter. That would mean I was wrong.
Full-time. He's full-time, he's taking a full course load, and there should be child support for that period. And they're trying to attack my client's income. But they're trying to attack my client's income, but I haven't seen, we've submitted W-2s updated as of this hearing. They show that he's making $2,000 more, because there's a little more business now, $2,000 more than at the time of the 2022 hearing, and we did both sides submitted income statements, none of which Mr. Johnson just said, oh, it's proven that we don't know whether we can rely on his income. There's been nothing to discredit his income. I didn't hear a question saying this isn't really what you make or anything. Now, at the time of the divorce, yeah, there was something that where the judge found $12,000 was really, or whatever it was, per month was the actual instead of what he was claiming. But, Your Honor, that was before when he had businesses which have been dissolved or which he is no longer an owner of and has to actually pay money to Mrs. Parker for. They're no longer existent. He had the Bojangles thing, which no longer, it's gone, it's done, it's been sold off, it's not producing income. His income is different. And he is not an owner of the companies that he works at now. His mother is an owner, but he is an employee. He gets W-2s. We submitted 3 W-2s for this year, for 2024, and that amounts to his income. And Mrs. Parker, although she's now saying her income is a little bit different, my understanding is still receiving what she received when she was at the sheriff's, probably still at the assessor's office. 2023, which is after the 2022 worksheets, she was making over $71,000. Now she's saying today with her new, what she submitted today, that's a little bit lower. Again, it's really not even that important how much of a difference. I think there need to be worksheets done with the 6,600 and what was represented, what we proved from her personnel file, her income was, per our worksheets. We proved what it was in December 2022, and I think that needs to show. There needs to be a worksheet for each person to be owner for 1 child. And I think.
Whoa, do you have to? Is it financially that you must, or workload-wise you have to, or are you just doing this because you think that's what you're supposed to do? Because you're not. you need more time because of everything.
There needs to be an offset. And according to our calculations, the offset would be $134 that my client would have been paying her this entire time. To go back and suddenly operate off $4,187 while my client had full responsibility, and it wasn't his fault. I understand Sheriff Wiltshire was sick. That Sheriff Wiltshire, that there was a continuance for that. The court had something that came up too that moved our date. It got moved, and we didn't get a resolution on the child support for an extra 2 years. And they're asking you the whole time to have him still paying for private school that the children do not attend for 2 years at the full amount of child support at a much higher amount. We filed going back to 19/6/15, and that the court can consider from the date of the filing, and it should have been a different amount. And it should definitely be a different amount from the date that we said. And under the Unedema case, he should receive credit and an offset. And we're going to ask that those offsets, whatever they may be applied against whatever arrearages the court finds that my client might owe. Now, we've come up with what child support should be going forward. My client said he doesn't even really want child support, but going forward, based on our worksheets, him having both children from today forward, he owes, and I put what the incomes are, $1,005 a month. She would owe in child support. And I think that needs to be credited going forward. If there's no child support, that could be an offset. I have no idea. He said he doesn't care to receive the money, but he definitely doesn't want to be paying money that he shouldn't have to pay. But that's going before we even get into it. My client obviously has incurred child rearing expenses. But let's go to the actual arrearages. And I said it before, and I'm going to state it again because this does need to be clear.
JK, thank you so much.
I understand why Your Honor is frustrated, but I did make very clear yesterday when it was brought up, I was not prepared to argue a contempt and to argue all that. And we did have 3 days of sworn testimony and transcripts. All of this stuff presented up until a certain point in 2019, I believe. And that's all on the record. There was extensive evidence and exhibits, and it was coming up to our day to finish. And that's when we never had another hearing. And then this all went away, and then we've been in these cases ever since. And suddenly they came in and they wanted to what's before the court reporter right now. If the court looks, it's this case number, and it says motion hearing 2 days, all outstanding motions in this case, not in other cases. We agreed, hey, let's not stretch this out, we'll go forward, but they want us, and now I am going to address all those numbers that say, oh, this is straightforward. It's not straightforward. If it was straightforward, Mr. Johnson Sheets, he wouldn't have had to lead his client to say that $6,000 in alimony was due when it was overdue, plus interest. He wanted interest on all that, and it turns out it's not due. Their alimony, they now concede, but they made a big deal when I started going into it. They made a big deal about it. They were wrong. The information was wrong. And so to take Mrs. Parker, and I understand why it's complex to put this all together. It's all complex. In fact, most people don't have a payment that they have to make of child support, an alimony payment, and a separate payment that has to do with a payout on different dates and different time periods. I can understand why it would be confusing. But for them to just assume that we should rely on their numbers and her saying that he's in arrears when he's not, when we showed the alimony was 100% wrong. I think when it comes to Low Country, the most they were saying that he was in arrears was $5,000, even though if you look at their entire exhibit, it comes out to $57,000. That's part of their record. They went out.
$57,000 or $5,700?
Yeah, if you go out, they have it till 2028 for dates that haven't even occurred yet. And that's my point, is the court could be back there looking at it or giving it to a staff attorney, and they might say, well, hold on, I see $57,000, the judge said, and we could have a problem there. $57,000. $5,100. We pointed out that my client did overpay alimony. Any which way that they slice it, he overpaid and made another payment. They had 15 months, including what turned out he made 13 payments, 2,000 over. One, no alimony was willful, and there was no alimony arrearage. If anything, well, not if anything, he overpaid, and that should be credited. So we shouldn't be talking about the interest, and again, they had a much higher amount than their statutory interest. Now, when we get to Low Country drug screening, It says in there 15.28 months. That's what the order says. The order came out September 18th, 2018. I don't know if you can start 15.2 out. It's not written the same way that child support, which was prorated. It says he gets a 15.28 month extension because of the 19,100, whatever the court came up with, of payments. And so by his calculations, she started at September. She said September 1st, he was required to start making payments. That's not true. It didn't say that. The logical thing would be to start the payments from October. And for October going forward for 15.28 months, he had a credit, which she did account for, but her ending of that credit starts sooner. The 0.28 fell out in February 2020. Well, his understanding, or he thought he could start it even the next month, March. He hasn't missed a payment. By her own worksheets, it looks like there's even one. She couldn't explain why there's a $2,500. They're saying, well, you didn't credit him for the $1,500. I see $2,500 written that month. It showed at the top $2,500 that what was received that month. There were no arrearages any month around there. And yet she has a $2,500 that she deposits, but only shows one check. We have shown missing checks. She came in here today and said, well, I was off by a couple. Well, we think she's off by more. And if you start with March instead of the other months, which would have been maybe a misunderstanding or something unclear with the order, he is up to date on those.
It's not 31 minutes longer, don't worry. I'm just pausing it for a second because did you see it get all choppy? I'm a little worried. I'm just letting it catch up. I'm just giving it a second. I don't want it to crash. I don't want nothing to crash. Oh, I'm so absolutely doing that at home. Absolutely. Do you have any? I have one of the things. I need the other thing. Do you have any? All right, I'm going to press play.
He's made the payments. If you start when she says it should have happened, starting September 1st, which is 18 days prior to the final order, starting the obligation that date, start crediting that way, well, then you have a different issue. And then your obligation starts in January instead of March. And then you have a arrearage. If you do it the way we do it, there's not an arrearage. He's still going to have to pay the same amount. He's still going to have to pay. It's just going to be 2 months longer. So I don't think there is any arrearage that's been proven on Low Country. And luckily, we had lunch to look at that and see when she started calculating those, and it was before. We get to child support right away. And I know they want to minimize this and say, well, it's very straightforward. It makes sense. Just look at the sheets. No, it doesn't. One I showed, and they're minimizing the fact that she writes a November payment on October, which I think should draw some issues with. Obviously, the work is only as good as the people that are preparing it, and people can make mistakes, and this is confusing. But she started the payment dues she does for September 2018, part 1 and part 2. And she gives him some credit for some payment, but she basically applies more than what the obligation was. We showed what the amount per day would be per Judge Park's explicit order of prorating. It was $135 and change a day, or whatever it came out to. And in the end, we ended up with showing that she had a $1,000 payment. That month, he had already paid the tuition, which subsequently is included within child support. And so, if you do that, he had an overage in September because he only should have paid around $1,600. And he ended up paying over $3,000. He ended up paying $1,407 and change.
So you know what, guys? We were all wrong. She actually owes him about $150,000 now by his calculations. I think so. Oi, oi, oi.
That's an overage. If you make that mistake going forward, you're going to have arrearages every single month. And that's what Mrs. Parker did. She also, if you look, and we did deposit, we gave you all the worksheets, all the documents that she provided that include her sheets and his Venmo, her bank accounts. It's got the Heritage. I think it's a Heritage payment that shows the 1 month where we're showing the education payments that offset for September. But if you look at all that, you're going to see figures that clearly work out. It didn't make sense to her, and it looks like my client overpaid or paid the proper amount through December of 22. Starting January, he went down to his interpretation, which he thought it meant, now I have one child, I pay half. Really, if you look at the order and what our argument is, he should have paid $2,800, whatever, under the order, until the court issued a new order. However, the reality is,
I just don't think he's ever going to shut up. I think he's just going to keep talking forever, and I don't know how to make it stop.
the court can, under the Unanimous case, go back, and the court should retroactively go back and award child support, credit him for what the offset should be for the period of time he had. And then you wouldn't have this issue of all these payments and problems and discrepancies. But my client cannot control when Mrs. Parker deposits a check. And if she deposits a check the next month and then counts it late for a month and then applies interest on it, that's a problem. And that's what happened. If you look through her sheets,
that didn't happen.
Very nice, but they're flawed. That's what happens. And if you compare with all the underlying documents, which are now in evidence, and the ones that were in evidence before, you're going to see that that's what happened. But she has applied interest throughout every single year. And in reality, I think that the only arrearage that could be determined here would be, and she has been, this is important to distinguish too, since December of 2022, they have counted an arrearage of $4,187 a month. When in reality, my client paid $2,100 each of those months, which they acknowledge up until August of 2024. So there would be a credit, there would be an offset, and he probably would be in the plus column. I know this is confusing, it really is, but that's what I was asked to come in and figure out with new sheets that they laid on me this morning. And they're saying there were only 3 changes. There weren't. I looked through. When they changed things in those 3 places, they changed them in other columns too. I started comparing numbers, and the numbers were all different in different places, not just in 3. They may have made 3 changes, but that changed everything. And again, that is saying that everything matches up with her rendition of the facts, which they don't, and the documents show. So, Your Honor, what I think should be blatantly obvious to everyone is, with regard to those 3 issues and the convoluted nature of the calculations, his contempt is not willful if there is any contempt. Definitely not willful. A willful person doesn't make payments, doesn't try. They're saying, oh, he's got all the money for whatever he wants. He's still got to live life. But he has made payments every single month.
Go subscribe.
And more than most people make. He's been making it for years. Every month, $1,250. Every month, it was always $2,100 at least. And for most of them, it was $4,187 until December of 2022.
Liar.
So, plus, he has had a child this whole time. That's expensive. Thinking that Mr. Brigman suddenly, he's got all this money to just hand out because they want the money. I mean, he's tried to make his obligation. That is not willful contempt. It does not merit incarceration. Now, you heard Mr. Brigman's testimony, and it has been unrefuted that, yes, there is a attorney's fees obligation out there that's been out there. There's been a FIFA filed against his accounts. There is a lien that they have put against his house. He wanted to take out a loan to try to pay off those fees, and he can't because they won't give him a loan because Mr. Johnson has a lien against his property, or Mrs. Parker does, well, one or the other. There needs to be a credit on that, and in the end of the day, I'm going to try to make this slightly easier for the court if it hits at all. Yes, we have shown that coming into March 21st, our attorney's fees were $127,721.47. And yes, I did cite the statutes. I put in my proposed relief, in my affidavit, I put cases that show that one party prevailing should be entitled to fees, that the prevailing party is the party successful, even if not to the extent sought. And yes, we did say that Parker was definitely modified, so we should prevail. But without getting in there, my client's not asking that she actually give him $127,000. He's incurred that. He has had to fight this, and regardless of whether or not Everyone likes Mr. Brigman and thinks that he's honest on everything. I would say that Mrs. Parker has done her share. She's contributed plenty. That's the reason, unfortunately, that her children right now do not want to be with her and have been so adamant. She did that to herself, and this took two to tango. And Mr. Brigman was attacked from every which side and has been. And does he have his faults? Yes. Has he done things wrong? Yes, but so has she. And at the end of the day, I think that there should be an award of fees, but it shouldn't be paid. I think that if the court feels like paying it, great. But I think that it should be an offset against the fees they're saying are outstanding to some extent. Asking my client, who has taken care of two children this whole time, which she essentially surrendered the second one, whether she admits it or not, she's saying, dancing around and wants to have it both ways. So, Your Honor, I'm asking that he not be found in willful contempt. And I understand. I'm hoping this case is finally over. Thank you.
All right, thank you.
Can you just put the lawyer in jail for contempt and not the dad? Or both? They could just talk to each other the whole time. Give them a calculator while they're in jail, though.
All right, I'll take this under advisement. Thank you.
Oh my God! Should I just
And is the court just going to address the attorney's fees on brief?
Yes, please. No more hearings.
Thank you.
Meaning you're going to...
2 weeks, send me your attorney's fees.
What was that? Oh, you did.
Argument about attorney's fees for this. All right, Madam Clerk, I'm going to give you
So
these
you mean-
and I'll get them back.
Hold on a second. Wait.
Have you already submitted it? If you've already submitted
I
it,
submitted an
don't worry about
affidavit
it.
with some argument, but it was through March 21st.
Okay, well, if you want to send it through March 25th, then that's fine. Okay.
How long on that, Your Honor?
2 weeks.
2 weeks.
And is it okay in the form of an affidavit, which is...
That's fine. However you want to submit it in writing.
Thank you, Amy. Thank
Oh,
you.
obviously. Your Honor already
So
took...
2 weeks will be, just so I'm clear, today is the 25th.
Hold on a second.
So 2 weeks will be the 8th.
Is there any way to, Your Honor, extend that? I have court almost every day till then, and that goes into Passover.
Okay. When is Passover? What
It
is
starts, I leave the country. It's the only time me and my family are going for this. I leave on I think it's the 8th or the 9th. And I have trial literally booked up until then. I just
okay?
have to be...
18th, okay? April 18th.
Hold on, let me tell you when we...
You've already submitted stuff. You just got 4 more days worth, right?
Well, technically, but
You said you submitted through the 21st
I said, right, what was an affidavit?
of March, right? So you just got 4 more days worth to submit, right?
Probably. Yeah.
Okay, so what's the problem? You've already made your argument about why you
I
don't
don't have enough time to actually...
Well, I don't need one of your 20-page dissertations. It's just 4 more days worth of attorney fee
Okay, if
evidence.
that's the case, then yes. If we do it for the 18th, I should...
Okay, April 18th. All right, thank you.
And Your Honor is going to, I guess you reserve the part of the contempt, which we argued, and his...
Yeah, if you got some evidence you want me to look at,
No, I'm saying the response. Well, it's basically just on the motion, meaning the contempt.
okay, I don't know what you're asking.
We have, as part of this motion today, we covered also that she was in contempt
Yeah.
not sharing information.
No, I'm aware.
Mr. Johnson made that motion, and I gave you my response in terms of...
Yeah, I got all of that.
And if you need, would you like me to send you the Nenema site for...
That's fine. You can send it to me.
Look at my proposed relief. I've actually
You cited
cited
it?
it in...
Okay.
Check.
All right, thank you.
The other one I referred to.
No, that's it.
Finally, thank God. So she's going to go through all that stuff, and they're going to go over attorney's fees in 2 weeks. So just so you know, there's always all these cases going on. So there's no real, I don't know how this will ever end. Just like Candace, there's no real. He didn't go to jail. He might go to jail. We don't know. She didn't rule yet. But the judge is going to look at everything. And the judge is going to give her decision. Probably, I doubt she'll give her decision in 2 weeks during the attorney's fees hearing. She'll probably give a written decision before then. But that poor judge. But it doesn't matter. Do you guys remember the treehouse case that was in front of that judge? That was an awesome case, wasn't it? I remember that case. It was really good. I think if you don't want to be traumatized, then you should just say goodbye now, because I'm about to play a tiny clip to get us over this trial that we just finished. I'm about to play a tiny clip that CJ sent to me. Actually, she didn't send it to me. I'm sorry, I said that wrong. I just use words. She put in Discord for everybody under the um, Place Videos Here channel. Oh my lord, she just put another video there and it's really good. Whoo! No, I'm very distracted. I'm going to show you what she just sent first. What were we saying? What were we doing? Are we starting a trial right now? Sorry. CJ, I'm working here. So, while I get this pulled up, do you know I said we were going to start a trial today? That's not what I said. I was going to start recording a trial today from Kathy Thomas, Judge Thompson, or Thomas, I don't remember, in Harris County. Well, it was postponed 2 weeks because of a whole bunch of things. It's a murder trial, though. I did find out it's a murder trial. So in 2 weeks, I'm going to start that trial. Hopefully, unless it's
Spiders!
just so you know, I'm gonna have to mute part of this because it's inappropriate. But you can see it because it's in Discord. You can just go to Discord and see it. We put all kinds of things in Discord, guys. All right, this is. Whew, here we go, guys. Are you ready? I don't. I don't want to press play. But her accent is not even close to as good as CJ's. Not even a little bit close. And do that for anything. When you're reacting to something bad, it's okay to react, but you can stop that and make sure your logical brain kicks in and just say, okay. Just remember that. Remember this video. Food, not friend. No, that's not what it says. I love her. I think she did a spectacular job on that. Yes, she did. CJ, thank you so much for sending all of us that. Now we're all freaking traumatized. I was traumatized the worst when it was laying flat, when they opened the trunk and it was laying flat, suspended from the ceiling. Yeah, I stopped it. It's done. It's over. It's over. And if you want to know what was cut out, because it's a little bit naughty, it's in Discord under Place Videos Here. Oh, yeah. Wait, did I say something bad? Did I say something? Why am I in YouTube jail? What did I do? I'm sure I said something, but it's okay. YouTube is either going to get me or not. They're not going to get me. What? What? I don't understand. Defazi just sent me a message saying, you seeing what we seeing. I don't know what you're saying. I got rules violation. Hey, Beverly. Am I still streaming? I'll cut that part out. You guys can all see it anyway. I don't know about you, but that spider was scary in that car. Oh, they shut off my stream? Is it back now or is it just gone? The stream's just gone. It's fine. I'll cut that part out. It's not a big deal. Whew. Yeah, I break the rules. Breaking the law, breaking the law. Breaking the law, breaking the law. All right, I gotta start OJ. I gotta work a double today. So I have to start OJ quick and then turn. Oh, yeah, like I was saying, that trial was stopped. So April 15th, that trial is going to start. And then I also said I was going to get Juanita Jackson today. Well, two bad things happened. Three bad things happened. Juanita started late. And I can't just sit around and wait. So I started recording Ruiz Rodriguez from court. I don't remember. Court 11, I think. Court 11 in Harris County, Texas. And unfortunately, when Juanita started up her court, he was like off the bench or whatever. So I did not realize he was still playing. So, and I was really tired. Juanita started. I started recording her stream, went to bed, not realizing Ruiz was still open. So both of them were open. You see Juanita, but you could still hear Ruiz's courtroom in the background too. So there's two courts playing the whole time. And three, I think she got a new microphone. It doesn't work. So I'm dying to get a clip of her for you guys, but it didn't work today. So none of the things that I wanted to do today worked. So I didn't get anything today. Fozzie, I tried. I don't have anything to make a video out of because I don't have anything. I'm working on it. I didn't get a lot of clips last week because I was in Texas. All right? I was in Texas for days. So I'm working on it. But I have another trial set. We're going from where were we? Georgia. To the other part of Georgia with the accents. So we were just in Georgia, accent-free Georgia, so North Georgia. The trial I'm going to show you tomorrow is not as long as what we just saw, but it's southern Georgia. So, and it's not funny, but it's a domestic violence trial. So we're going to start that tomorrow. That's what I have for us for the next couple days. And then there's Idaho. There's a trial in Idaho that I want to start next, but I don't know if I'm going to. And this is a Daryl Brooks type trial. So she is on for murder and is going pro se and constantly argues with the judge. Over and over and over again argues with the judge. It's great. But I don't want to start that trial if it's going to end in a year. It's a murder trial. So I don't know if I'm going to start that trial next. We'll see. I'm just going to get through the next trial and then we'll see what happens. Thank you so much for coming out today. I really appreciate it. I will fix the stream. It's easy. They tell you what to click and it just goes away. Please go see CJ's accent, and then you can tell me which accent is better. Who wears this accent better? The lady we just saw until it was cut, or CJ? CJ has the best accent. Oops, that's Facebook, but it's the same. We are also on Twitch. Oops. Yes, you do, Beverly. Thanks, guys. Have a great day. I'll see you in OJ soon. Bye.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps. a giggle. She likes the